We'll go ahead and get started with the hearing portion of our meeting today, the docketed items. First, I want to make sure that we're prepared to go on the record. Michelle, I assume is our court reporter today, but I don't see a picture of her. Oh,
I'm here. I'm ready.
Great, thanks. Sorry I didn't see you before. Mr. Church, can you hear me? Give me a thumbs up. Yep. Mr. Brown?
Good to go.
Mr. Borden? Great. Looks like we have everybody ready to go. So we'll go on the record. Now, our first docketed item for today is docket number 2020-033, cause number RO&G 2020-02. In the matter of formal rulemaking to develop procedures for assessing administrative penalties resulting from Senate Bill 148. I believe that Mr. Lyons, you're going to be representing the division on this and presenting this information to us.
Correct. Can you hear me okay?
Yep, and we can see you.
That's even better. Okay. So yeah, just very briefly, I don't have a lengthy presentation for you today, thankfully, because we've come a long way since this administrative penalties rulemaking was initiated in October. There's been a lot of great discussion between the division and stakeholders along this path to where we are today. So the division last presented these administrative penalty rules at the March 24th board hearing. And at that hearing, the board directed the division to send those revised rules for publishing in the Utah Bulletin. And the rule was published on April 15th, which opened another round for a public comment. That public comment period has since closed. The division received only one public comment in the form of a letter from the Utah Petroleum Association, which fully supported the rule as published and requested the board to adopt the rules without any further modification. And the division feels equally as strong about the rule in its current form. So at this point, the division simply would just recommend that the board direct the division to send a notice of effective date to the Office of Administrative Rules and make the effective date for May 25th, 2021.
Can I clarify? I think Charles said May 25th, but I think what he meant was May 27th.
That's correct. May 27th. I don't know why it has May 25th in here, but thanks for that, Haley. we could make it 25th if we wanted to, but let's make it the 27th just to be safe.
Okay, thank you. Sorry, I was just having a conversation with our counsel. So, what's been requested, board members, by the division and Mr. Lyons, is that the board vote on authorizing the rule and setting an effective date of May 27th, 2021. Any comments on that from the board members? Any questions? Any discussion? Hearing and seeing none, then a motion would be in order to accept or authorize the rules and set an effective date of May 27th, 2021. Board member would like to make a motion?
So moved.
Is there a second?
Second, this is Rich Borden.
All right. Any discussion on the motion? So the motion is for the board to approve the rulemaking that developed procedures for assessing administrative penalties resulting from Senate Bill 148. Julianne, would you call the roll call vote for us, please?
Mr. Richard K. Borden, how do you vote?
Yes.
Mr. Michael R. Brown, how do you vote?
Yes.
Mr. Stephen B. Church, how do you vote?
Yes.
Ms. Susan S. Davis, how do you vote?
Yes.
Ms. LaVon J. Garrison, how do you vote?
Yes.
Mr. Chris D. Hansen, Chairman, how do you vote?
Yes.
Thank you, Mr. Chairman. I have 6 affirmative votes.
Thank you, Julianne. I believe that the motion is carried, and we've accepted the division's request, and the rules will become effective, have an effective date of May 27th, 2021. Thank you for doing this, and thanks to the UPA for working with the division and getting this move forward. We appreciate it. We can move on, I guess, to our next docketed item, which is docket number 20201-009, cause number 190-15. In the matter of the request for agency action of Wesco Operating Inc. for an order establishing a special drilling unit for the Kane County Unit 7-2R2-26-20 horizontal well for production of oil and associated gas and hydrocarbons from the Cane Creek Clastics, and I'm not going to read the rest of this. So at this point, I guess we would take appearances of council.
Fred McDonald of Council of Lear and Lear on behalf of Wesco Operating.
And
Thank you.
Haley Souza on behalf of the Division of Oil, Gas, and Mining.
Thank you. I guess at this point, Mr. McDonald, if you'd like to proceed.
Thank you, Mr. Chairman. With me this morning are Mr. Steve Degenfelder, who is the landman for Wesco, and Mr. Tom Kirkwood, who is the petroleum engineer, and I would ask that they be sworn in as witnesses at this time.
That would be great. Could we go ahead and have those witnesses sworn?
Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I didn't see Mr. Degenfelder, or,
Yes, ma'am, I said I did. I was on mute.
oh, okay, thank you.
Thank you.
Members of the board, the vitae of both witnesses were collectively submitted as Exhibit A in this cause. Both have been previously recognized as experts by the board. Mr. Degenfelder in petroleum land management and Mr. Kirkwood in petroleum engineering. Mr. Degenfelder, however, will only be testifying as a fact witness this morning. If separately and individually asked about the contents of their respective vitae, the witnesses would confirm the same. Based on his vitae and his previous recognition as an expert by the board, and with the presumed consent of the division, we would ask that Mr. Kirkwood again be recognized as an expert in petroleum engineering for purposes of this cause.
Division, any concern with that?
No, Chairman Hansen.
Board members? Hearing and seeing none, we will accept them again as expert witnesses.
Thank you. Also, I want to confirm that the board received the supplement to Exhibit Z, which is just the additional return receipts. Ms. Carter's indicating yes, that they were passed out.
Yes.
Okay, thank you. Finally, Mr. Chairman, just to confirm again that I will be moving for admission of my exhibits at the end of my presentation in chief.
That's preferred, yes. Thank you.
Thank you, Mr. Chairman. Members of the board, as you know, Wesco operates on behalf of Kirkwood Oil and Gas LLC and Nerd Gas LLC, including as serving as operator of the Cane Creek Federal Exploratory Unit in Grand and San Juan counties, Utah. As you may also recall, in its order entered in cause number 166-11 in March of 2019, the board authorized Wesco to drill the Cane Creek Unit 7-2R2-2620 well as a horizontal well targeting the Cane Creek Clastic oil production, but which was to cross the boundary of the Cane Creek Unit into lands adjacent to the east. Those lands were outside the unit are subject to 2 federal leases owned by Kirkwood and Nerd. The purpose of the well was to test the eastern productive limits of the unit, and if productive, to determine whether unit expansion was justified. A true and correct copy of the 166-11 order was submitted as Exhibit B in this cause. Pursuant to the 16611 order, Wesco spud the well on September 19th, 2019, drilled it horizontally, and completed as an oil well, which began production on November 20th, 2019. However, the well does not meet the unit paying quantities definition under the governing unit agreement, and therefore unit expansion is not justified at this time. However, as the testimony will reflect, the drainage from the well affects lands both within the fourth revision of the second consolidated paradox participating area of the unit, other unit lands which are currently outside of that participating area, and lands that are outside of the unit. Under such circumstances, the Bureau of Land Management regulations and guidelines require communitization, under which the agreement is to allocate production on a pro rata acreage basis to the portion of the leaseholds drained outside of the unit PA and to the PA as to the portion thereof within the drainage area. However, the BLM will not approve a communitization agreement without a conforming spacing order from the board. More importantly, as relating to the board, order number 4 of the 166-11 order expressly requires Wesco to seek a spacing order from the board under these particular circumstances. These are the reasons why Wesco is before you today, requesting the creation of a special drilling unit for the well. As the testimony and evidence will reflect, the Cane Creek clastics constitute one common source of supply of oil. Although utilizing different assumptions, as the testimony will show, Wesco advocates that the appropriate drilling unit should be the 440 acres described in the request filed in this matter, based upon a circle tangent method previously approved by the Bureau of Land Management for similar wells. Wesco is confident that no other lands beyond those requested for inclusion in the drilling unit are being drained by the well. Wesco is requesting that the drilling unit establishment be made retroactive to the well's date of first production for the production of correlative rights. Under Utah Code annotated section 40-6-6 subparagraph 8, the board has the express statutory authority to retroactively space to address these exact circumstances. Wesco is further requesting a 2,260-foot setback from any productive portion of the well to any other well that may be producing from the Cane Creek clastics be adopted. Finally, Wesco is requesting that should the well ever produce in unit paying quantities, and all of the lands that we are involved today are included in the unit and within that participating area, the requested drilling unit, if approved, will be suspended, the conforming communitization agreement terminated, and the unit agreement will then govern production allocation pursuant to the participating area. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6, 40-6-5, subparagraph 3B, and 40-6-6, subparagraph 6. The request was sent via certified mail return requested to the BLM, both at the state level and the Moab District Office, as the governing agency and an oil and gas owner, to the Utah School and Institutional Trust Lands Administration, who is a production interest owner within the participating area, and to all other production interest owners in the 4 federal leases covering the lands outside of the participating area and or the unit, as well as those within the participating area, all to their last addresses as disclosed by a search of the relevant BLM and Grant County Realty records and based upon Wesco's internal records. Notice of the request in this hearing was also published in the Salt Lake Tribune on May 2nd, 2021, in the Moab Times Independent on May 6th, 2021, and in the Deseret News on May 7th, 2021. No objections or other responses were received, and the division elected not to submit a staff memorandum in this cause. With that, I'll commence my examination of Mr. Degenfelder. Mr. Degenfelder, would you please state your name and business address for the record?
Yes, Mr. Chairman, my name is Steve Degenfelder. My business address, Wesco Operating, 120 South Durban, Casper, Wyoming, 82601. My current position with Wesco is landman with responsibilities that include the lease records, inclusive of the Cane Creek unit and adjacent areas.
Would you please state for the record what is Wesco's current corporate and bonding status?
Mr. Chairman, Wesco is a Wyoming corporation in good standing. with its principal place of business in Casper, Wyoming. Wesco is duly qualified to conduct business in the state of Utah and is fully and appropriately bonded with all relevant federal and state of Utah agencies.
Would you please provide to the board just a brief history and status of the Cane Creek unit?
Mr. Chairman, the Cane Creek unit was originally formed on April 15, 2002, where all formations were unitized. Wesco became the operator of the unit following the August 2016 acquisition by Kirkwood Oil and Gas LLC and Nerd Gas LLC, purchase of the Fidelity Paradox assets. The fourth revision of the second consolidated Paradox participation area comprises 11,478.24 acres in Grand County, Utah, which includes the north half of the northeast quarter and the northeast of the northwest quarter of the subject lands in Section 8, was approved and effective March 1st, 2017.
All right, Mr. Degenfelder, I'm now going to show you what have been marked as exhibits C, D, and E for purposes of this cause. Is everybody seeing the presentation right now? All right. As I mentioned, this is exhibit C, D, and E. C, D, and then E you should have in front of you. There's no PowerPoint to that. Do you recognize those documents?
Yes, I do.
Were they prepared by you or Wesco personnel with your review and input?
Yes, they were.
Okay, turning your attention now to Exhibit C, which is shown on the PowerPoint, would you please explain what this represents?
Yes, Mr. Chairman, the Exhibit C depicts the Cane Creek Federal Exploratory Unit and its outlying boundaries and the unit area colored in green. And it's approximately 10 miles west of the town of Moab. And the well that is in question that is the genesis of this spacing unit and communitization agreement is depicted in the unit area as well. The Cane Creek Unit 72R2 2620 well.
All right, now turning your attention to Exhibit D, please explain to the board what is all represented on this.
Sure, Mr. Chairman, Exhibit D depicts the proposed communitized area shown on your map shaded in light green. The first outlines, the fuchsia outline is the unit outline, and the red outline within the fuchsia outline is the existing fourth revision of the second consolidated Paradox participation area boundary. As I mentioned, the area in green depicts the drainage area that Mr. Kirkwood will go over later in the testimony, but it is comprised of 4 federal leases. Lease number 1, UTU 93005, which covers the west half of the southwest quarter of Section 4, UTU 68122, which covers the north half of the southeast quarter, the southwest of the southeast quarter, and the southeast of the southwest quarter of Section 5, and the northeast of the northwest quarter and the northwest quarter of the northeast quarter of Section 8. UTU 64820 covers the southeast quarter of Section 5 and the northeast quarter of Section 8. Finally, UTU 010529 covers the northwest quarter of Section 9. And as I mentioned, the participation area depicted in the red outline includes 2 of those leases, the lands in Section 8 that comprise 1 tract of that by virtue of their inclusion in the participation area.
All right, now directing your attention to Exhibit E, which again is not on the PowerPoint. Was that prepared by, that was prepared by our office, but was reviewed by you and with your input, is that correct?
That's correct.
All right, would you please explain to the board what's represented on it?
Yes, Mr. Chairman, Exhibit E is a complete, a detailed ownership status of each of the leases that are listed, are shown on the Exhibit D. And so each one of those, Track 1, Track 2, Track 3, and Track 4, and Track 5, which is the part of the participation area, are depicted with their working interests and their royalty and landowner royalty and overriding royalty interests.
All right, and who are the operating interest rights owner in this proposed communitized area?
The working interest owners in the proposed communitized area outside that participation area are Kirkwood Oil and Gas LLC and Nerd Gas Company LLC. Within those 120 acres in Section 8 that is within the participation area, by that contract, the working interest owners are Kirkwood Oil and Gas LLC, Nerd Gas LLC, and AG Androcopoulos Resources, Inc.
All right, and just as a reminder, how is production allocated within a participating area?
The production is allocated on a lease basis.
A prorated acreage basis for the tracts, is that correct?
That's correct, yes, on an acreage basis.
All right, would you now provide to the board just a quick history about the well and the need for a communitization agreement?
Yes, the well was drilled, and as you mentioned in your earlier testimony, was determined to be a non-unit paying well, which is a well that is unable to recover its drilling costs, completion costs, and operating costs, and produce a profit. So therefore, the unit agreement requires a communitization agreement to be established, and waits for the Department of Natural Resources to declare a spacing unit before a communitization area is designated for the well. The reason why this is done is that in the event the unit ever terminates or contracts to the largest participation area, any lands outside that might contain other lands and has to be taken care of prior to the contraction of a federal exploratory unit, if that ever occurs.
All right, now I'm going to ask you to refer to Exhibit F. Again, there's no PowerPoint for this. This should be a true and correct copy of a letter that Wesco received from the Bureau of Land Management. I presume that is an official business record of Wesco, is that correct?
That's correct. That what the BLM requires is for the operator to submit a letter to BLM requesting concurrence of their determination that the well is a non-unit paying well. And we did submit that letter and did receive that concurrence from BLM that the unit, the well in question was not a unit paying well, and therefore we should proceed with the Division of Oil and Gas Mining to establish a spacing unit. And once that is done and approved by this board, then we would submit a communitization agreement to BLM for their execution.
All right, and in response, did you ever hear any objection to the proposed area that would be communitized from the Bureau of Land Management?
No, we did not.
All right. Just to go back a little bit, just to provide some history of the well. The well was drilled pursuant to the board's 16611 order, is that correct?
That's correct.
And was my statement that that it was completed as an oil well and began production on November 20th, 2019, is that correct?
That's correct.
All right, thank you. All right, now I'm going to turn your attention to, well, first of all, let's go back. The well's been producing What has Wesco done with the production proceeds?
They have been placed in escrow pending approval of this application.
Okay, thank you. All right, now I'm going to ask you to turn to the certificate of service, which was a pleading prepared by my office. It should be in front of you. It's also on file in this matter. I want to know, do you recognize the names and addresses shown on that certificate?
I do.
And who are those parties?
These parties are the interest owners within the entire proposed CA area.
Including those within the participating area of the unit?
That's correct, yes.
All right, and how were those names and addresses compiled?
They were compiled by a record search both in the BLM offices and the county offices for the lands outside the participation area. And then inside the participation area, we used our JIB and revenue deck that we have internally here.
All right, for the board's attention, the Exhibit Z is supplemented, represents the true and correct copies of the return receipts or the return mailings received by my office, which was supplemented this past Monday to reflect those returned after April 23rd, 2021. It also includes any UPS inquiries as to any receipts that we did not get back or mailings that were returned. With that, Mr. Chairman, that concludes my examination. Mr. Degenfelder.
Thank you, Mr. McDonald. Division, do you have questions for this witness?
Thank you, Chairman Hansen. I do not have any questions for this witness, but with the approval of the board, I would ask if either Mr. Dane Doucette or Mr. Dustin Doucette have any questions.
Sure, please proceed.
This is Dustin. No questions for me.
Okay. Board members, I'm sorry, Haley, is there anything else you wanted to state or say?
Just thank you.
Okay. One of these days we'll get back in person, right? Board members, do you have questions for this witness?
I have a question.
Yes, Ms. Garrison.
This is LaVon Garrison. I have a question. So the lands that are currently outside of the unit, if those lands are not taken into the unit and you would plug this well, will those outside lands expire or are they held by some other wells?
Mr. Chairman, the lands outside the unit, Section 4 and Section 9 are not held by any other well.
Okay, thank you.
Seeing no other questions, we'll turn the time back over to you, Mr. McDonald.
Thank you, Mr. Chairman. I'll commence my examination. Mr. Kirkwood. Mr. Kirkwood, would you please state your name and business address for the record?
Yes, it's Tom Kirkwood. Business address is for Wesco Operating 120 South Durbin, Casper, Wyoming 82601.
And what is your current position with Wesco?
Currently a petroleum engineer over the King Creek unit.
All right, Mr. Chairman, I will ask the board, Mr. Kirkwood's ready to provide a brief overview of the depositional nature of the Cane Creek clastics, but the board has heard that several times, so I'm just going to ask if the board is inclined to hear that now, or if we can just skip over that with the understanding that the board has a good understanding of what that is.
Any objection from the board members that we can go on our past knowledge that has been imparted to us before? Hearing none, I think that's fine.
All right, thank you, Mr. Chairman. Mr. Kirkwood, I'm going to ask you to now look at what have been marked as exhibits G through I in this matter, excuse me. Do you recognize these three exhibits?
Yes.
Were they prepared by Wesco's geologists with your input and review?
Yes.
Okay, turning your attention to exhibit G, would you please explain to the board what this represents?
That is a type log for of gamma ray across the King Creek interval from the King Creek unit 7-2R2 well.
And was this law used for the definition of Cane Creek Classics for purposes of this cause?
Yes.
Okay. Turning your attention now to Exhibit H, would you please explain to the board what this represents and its significance?
This is a isopatch map of the Cane Creek across the area, basically showing that the Cane Creek is ubiquitous across the region and present.
All right, and just to explain, what are the contour intervals shown on here?
The contour intervals are 10-foot thickness of the Cane Creek.
And what is the significance of the net pay thickness with respect to this well?
Just show that it's consistent across the area.
Okay, and it also shows the cross-section that will be utilized in the next exhibit, is that correct?
Correct, yes.
Okay, now turning your attention to that exhibit, Exhibit I, would you please explain to the board what this represents and its significance?
This is a cross-section starting in the northwest, going down to the southeast of the map, previously shown, also shown in the upper right-hand corner, showing the Cane Creek interval across the bottom in the reddish color.
And the main takeaway is that it's continuous through there?
Continuous, yes.
Okay. And what is the approximate net pay thickness?
About 26 feet, 25 feet.
Okay. In your opinion then, does the Cane Creek Classics constitute a common source of supply for oil and associated gas and hydrocarbons?
Yes.
Okay. Now turning your attention to what have been marked as Exhibits J through O. Do you recognize these exhibits?
Yes.
And were they prepared by you or Wesco personnel with your input and review?
Yes.
Okay, turning your attention now to Exhibit J, would you please explain what this represents?
This is showing the wellbore path starting in section 7 and terminating in section 4. The toe of the well did end up being wet and not oil productive, so it was plugged back to the depth of shown at 11,362 feet is the intake point for oil and gas production. It also shows the overlying drilling or spacing communitization area we're requesting. Okay, and could you please explain the landing point, what that means? Yes, due to geographic conditions in the area, the surface hole location is in the northeast of 7, but we directionally drilled it over into the middle of 8 and 5, and that's where it had been in the Cane Creek formation.
So that's the first take point of the well?
First take point, correct, yes.
Okay, all right, thank you. Turning your attention now to Exhibit K, would you please explain to the board what this shows?
This is a wellbore diagram of the 7-2R2. It shows the perforated interval as the darker gray spotched area, and the cement plug and cast iron bridge plug that's plugging back the well at the depth of 11,291.
All right. Turning your attention now to Exhibit L. Please explain to the board what this represents and its significance.
This is a production history of the well, as well as the forecasted decline curve used for the economics and ultimate recoveries of oil from the well.
All right, now turning your attention to Exhibit M. This is a 2-page exhibit. Starting with page 1, would you please explain what it shows?
This is how the volumetrics were calculated. Originally, we used the Vasquez-Beggs correlation to determine the formation volume factor for the well. And at that point, we were able to calculate the drainage area the area that would be drained based upon net pay thickness, formation volume factor, and other things you'll see later on. At that point, it was determined that 192 acres would be drained by the well, and using the circle tangent method with a lateral of 1,924 feet, that gave a radius of 1,130 feet. And then all 40 acre sections that this circle tangent had been crossed was included in the communitization area.
Okay, turning then to the second page. Please explain what this shows.
Yep, this is the data entry that was input into the Vasquez-Beggs and the net pay calculations to determine my ultimate recovery and original oil in place that was used for the drainage area.
All right, now turning your attention to Exhibit N, please explain what this shows.
This is showing the circle tangents that were used, centered on the take points with the circles of 1,130 feet. And then the green area showing that those sections were included.
All right. Now turning your attention to Exhibit O, this is a 2-page exhibit. Starting with the first page, please explain what it shows.
These are the engineering assumptions that were used to determine the ultimate recovery of the well. We used a NYMEX price of $53 with an oil deduct of $6.75. Operating expenses were $27,125, decreasing $1,500 per year until $18,125 per month, and it was held constant at a working interest of 100% with a net revenue of 79.8.
Right, turning to the second page, what does this show?
This is the monthly cash flow showing the economics, showing the gross production of the 133,000, which is the same that was used in the drainage calculations, and also showing the capital cost and the non-unit paying determination value on it.
All right, and finally, the third page, what does that show?
That's just on an annual basis as opposed to a monthly basis.
All right. Part of the request that Wesco has asked for is a 2,260-foot setback to any other producing wells from the Cane Creek Classics. Can you please explain how that came about and how it will prevent communication with the other wells?
That was determined by basically doubling the circle tangent radius, assuming that the well next to it would be similar to this well, doubling that radius so that the new well would not be draining this well's drainage area.
So what are also the geologic characteristics here that would impact that, to say that are different than the Uinta Basin, where the board is familiar with a lot of horizontal drilling?
Yes, so these wells are not stimulated. They're relying on natural fractures, which greatly decreases your recovery factor, and also doesn't allow for as much take points as opposed to a tight sand or a shale that you see in other basins.
All right, thank you. So in your expert opinion, based on the data generated to date, will the proposed drilling unit not be smaller than the maximum area that can be economically and efficiently drained by the subject well?
Yes.
All right, Mr. Chairman, that concludes my examination of Mr. Kirkwood.
Thank you. Ms. Souza, do you have questions, or does your staff have questions for this witness?
I have one question. Can Mr. McDonald, can you go back to Exhibit N? So this shows the communitization, the proposed communitization area with, using those circle tangents. Why does the proposed communitization area extend so far out beyond the exterior of that farthest out circle tangent?
That's just the 40 acres. Every 40 acre that was touched by the circle for the circle tangent was included. Is just the way that it's been done past in this area.
And that was my only question. Mr. Doucette, do you have any questions?
No questions.
Thank you, Chairman Hansen.
Thank you. Board members, do you have questions for this witness? Ms. Davis.
I guess my question is, if the current well doesn't produce in paying quantities, why are we doing a communitization agreement at all?
It doesn't produce in paying quantities in that it won't pay for the drilling of the cost, but it will pay for it currently makes money. So it's supplementing some of the cost. It just won't pay for the entire cost of drilling of the well.
Right, I understand that, but why drill more?
The King Creek area is a highly risky drilling area. However, there are some incredibly productive wells. Wells in the unit have produced, in excess of 750,000 barrels of oil in a short period of time. It's not quite as repeatable as some of the other basins are, but there is a chance to drill wells and have producing, paying wells out there.
Thank you.
I have another quick question. The fourth revision covers more than just the Cane Creek plastic, doesn't it? Doesn't it cover more of the paradox plastics?
Yes, but my understanding is it covers the entire paradox formation, which is
Okay.
consistent of salts and shales and hydrates, and they're stacked depositionally. And it covers from the top of the paradox to the base of the paradox. And the King Creek is a section of the paradox.
And what you're requesting in this application is solely for that one Cane Creek plastic. Is that correct? From 7,000, I don't remember
Correct.
the exact.
Yes. Yes.
7672 to 77646, and not any of the others.
Correct.
Okay. Thank you.
This is Rich Gordon. I have a quick question as well, if I may.
Go ahead.
Yeah, I just want to follow up a little bit on the request for the 2,200 foot setback. Is the Cane Creek plastic target, is it highly permeable? Is that why the setback is so large? Or do you have evidence that the fractures you were discussing, that secondary permeability, have a lot of very long lateral continuity?
It's just the kind of the method that's been done in the past out there, being that you don't put any hydraulic fracturing on it, and it is completely dependent upon very high perm, large fracture production on it. The total drainage area can't be calculated based on half lengths or anything that you see on a lot of other areas. So that's kind of where that had come from anyways.
Okay, thank you.
Mr. Brown.
Mr. Kirkwood, I understand the natural fracturing of the deposit here, or the reservoir, I guess is probably a more appropriate term. You say because of that fracturing, it's not stimulated or hydraulically fracked, but could it be? Could the recovery be enhanced? Could the radius of recovery be increased?
So there's been some studies of stimulation. There's been probably 5 of them done in the King Creek unit, and they've all been performed with mineral oil in very small, like less than 200,000 total pounds of sand, just trying to get past some near wellbore damage, and that is generally caused by drilling. There has been some wells down in the 3 Mile unit down south that had been stimulated with large water stimulations, where you would get large frac growth from it. The issue that seems to be happening is you've got your King Creek formation, and then above and below that you have a salt, and you end up fracking it. Your fracture grows up into your salts. It doesn't have a good conformance area on the top and bottom, so you don't get a whole lot of growth, and a lot of times it can bring in supersaturated waters. That being said, I don't know if there's something in the future that could help out on that. Like I said, the mineral oil stimulations have had pretty good success on some of the wells, but they're all very, very, very small. I mean, less than 3-4% of the stimulation sizes you see anywhere else.
So my follow-up question to that is then you still feel that the 22 160 setback is conservative with respect to correlative rights and protecting those.
Correct. Yes. Yeah. Yeah.
Thank you, Mr. Chairman. I yield back.
Thank you, Mr. Brown. Any other questions? Hearing none, we'll turn the time back over to you, Mr. McDonald.
Thank you, Mr. Chairman. Mr. Degenfelder has advised me of a misstatement that he had in response to Ms. Garrison's question. Mr. Degenfelder, do you want to clarify the status of the Section 9 lease?
Yes, Mr. Chairman, it just came to my realization that a question that Commissioner Garrison asked me about the existing wells on the lands outside the unit in Section 4, there are no producing wells, but in Section 9, there is one well, the Long Canyon #1, which is a old vertical well that is in the southeast of the northwest quarter that is currently a productive well. So I'm apologize for not answering the question correctly the first time.
Thank you for the clarification.
Anything else, Mr. McDonald?
No, Mr. Chairman, that concludes our presentation to Chief. If it's appropriate at this time, I'll move for admission of the exhibits.
Sure, go ahead.
All right, please, I'd like to move for admission of exhibits A through O, including the multiple page exhibits, and Z as supplemented.
Okay, those are admitted. Division, Ms. Haley Sousa, do you have presentation by the division?
I do not have a presentation from the division. However, I will take this time to just state that based on the testimony that has been presented here and the answers to the questions that were posed, the division does not oppose granting the requested relief.
Okay, thank you. Well, I guess at this point then, we turn back over to Mr. McDonald for summation.
Thank you, Mr. Chairman. As you recall, the 16611 order said under these particular circumstances, excuse me, that if the well was not going to result in unit expansion, that Wesco is required to come back and seek a spacing order for the well. Just to try and clarify for Ms. Davis, the unit paying quantities is defined in the unit agreement as not only covering operating costs, but also to operate as a profit. Whereas federal leases, the standard for them to be paying quantities is just to cover the lifting and the operating costs. So that's why the well is producing. It just doesn't meet the unit definition, and that's why we have to seek this communization agreement. So in accordance with both the board's order and then the BLM's guidance, that's why Wesco has come forward with this. As we mentioned, the Bureau of Land Management is supportive of this. They have no objection whatsoever to the size of the communization agreement, of the communitized area, excuse me, and the methodology that was utilized. So with that, we submit that Wesco has met its obligations, meets all the statutory requirements for establishing this drilling unit, and we ask that the board approve the request as submitted. Thank you very much for your time and attention.
Thank you, Mr. McDonald. Since the division really didn't have a presentation, I think unless there's any objection from Ms. Sousa, the board can discuss this at this time. Board members, do you have any further questions that you need to ask before we either deliberate or have a motion in this manner? Hearing and seeing none. Board members, do you believe you're ready to move forward on this, or would you like to deliberate and discuss it for before a motion is proposed?
I'd like to deliberate.
We will take some time to deliberate. We will go off the record and deliberate on this matter. Board members, go ahead and move over to our other site for communications, and we'll be back as soon as those deliberations are complete.
So good.
All right. Looks like we're ready to go back on the record. I see that Mr. Borden, Mr. Church, Mr. Brown are up, and Michelle, I see the court reporter is there. If you can just give me, okay, got the thumbs up there. We will go back on the record at this time. We deliberated, and I believe that board members, there's a motion in order.
Yes, Mr. Chair, this is Steve Church. I move that we approve the matter as requested.
Is there a second?
I'll second the motion.
Any discussion on the motion? Hearing none. Ms. Julianne, would you please call the roll call vote?
Mr. Richard K. Borden, how do you vote?
Yes.
Mr. Michael R. Brown, how do you vote?
Yes.
Mr. Stephen B. Church, how do you vote?
Yes.
Ms. Susan S. Davis, how do you vote?
Yes.
Ms. LaVon Garrison, how do you vote?
Yes.
Mr. Chris D. Hansen, how do you vote?
Yes.
Mr. Chairman, I have 6 affirmative votes.
Thank you, Ms. Carter. The motion is passed. And Mr. McDonald, would you please write the order?
Certainly, thank you.
Thank you. All right, we will move on to our next docketed item. And one thing that before we start, depending on how long this matter takes to hear, we will probably plan, if there's a break point, if it goes this long, sometime around noon. So just bear that in mind as we get started here. We will look for a breaking point sometime around noon. The next docketed, the next docketed item is number 2021-010, cause number S//023/0015 in the matter of notice of agency action by the Division of Oil, Gas, and Mining, seeking an order forfeiting the reclamation bond provided by Triumph Mining Corporation for reclamation of the Gardner Canyon Mine and other related relief. We'll take appearances of counsel at this time.
This is Charles Lyons for the Division of Oil, Gas, and Mining.
This is Alan Young for Triumph Mining.
Okay. I believe at this time we, well, it's a good question. Should we let the division? Yes. I'm reminded that there was a last-minute filing that came in from Triumph last evening on the 25th of May, sometime after 6 o'clock. Division, what is your pleasure about this late filing?
The division doesn't have any objection to allowing that filing to be admitted.
Okay. Do we need a motion at all to? Okay. I will exercise my authority as the chair and say that it's admitted as into the record for today. So typically, it seems to me in the past we've let the proponent go first in this presentation in this matter. So, Mr. Young, or I'm sorry, Mr. Lyon, would you please give your presentation?
Yes, thank you. And I also have Wayne Western here from the division as a witness to discuss this matter. And I would like to have him sworn in at this time. Wayne, are you there? I haven't seen you on the
Yes.
tiles. Okay.
Yes, can you see me?
Yes, and hear you. Great, thanks. Could we have Mr. Sorry. Yeah, go ahead, Michelle. Sorry.
Yes, I personally think it may be beneficial to the folks that may not be intimately aware of the situation to have an opening statement and a response so that you will understand the issues as we go forward here today. If you don't want one, okay, but I would think a little historical background and the reasons we're here this morning, I think might be helpful in the analysis of the evidence that will be forthcoming.
Division, you can proceed however you'd like to, whether you'd like to have a brief historical statement. I believe the board members have been briefed on it, but we'll let you do what you'd like, Mr. Lyons.
Okay, so I mean, just so you know what my plan is for this is to just have Mr. Western sworn in as a witness. I'll give a brief statement of the background for why this notice was filed, and then we'll just enter into questions for Mr. Western. And then if Triumph would like to follow up at that point, I think that would be the proper procedure in this matter.
Okay, I agree. So go ahead. Have
Okay.
Mr. Western sworn in.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. So also, I would just like to state that at the end of this division's presentation, a case in chief, that I would move to have all the exhibits entered into the record at that time. So as I just mentioned, I would like to give a background before engaging with Mr. Western to briefly outline what the division is seeking from the board today. So this matter involves the Gardner Canyon Mine, which is a gypsum mine located in the Uinta-Wasatch Cache National Forest in Juab County and operated by Triumph Mining Corporation. The division is requesting the board enter an order forfeiting the reclamation bond provided to the division, currently held by the Utah State Treasurer's Office to guarantee reclamation of the Gardner Canyon Mine. Second, to authorize the division to use the forfeited funds to reclaim the associated surface impacts from the Gardner Canyon Mine. And third, authorize the division to take any and all additional actions necessary to recover the costs of reclamation if the forfeited amount is insufficient to complete the work. So this request is contained in the division's notice of agency action, which was filed on April 12th, 2021, which was filed after the division issued Triumph a division directive to reclaim the Gardner Canyon Mine on March 5th, 2021. That directive required full reclamation of the Gardner Canyon Mine and included that the entire mine at least be regraded by April 30th, 2021. It also notified Triumph that the division would be filing this notice of agency action to forfeit the reclamation bond in the event that Triumph did not comply with that directive, adding that the division would delay this action if Triumph complied with that April 30th deadline for completing the regrading of the mine site. And so the division's notice of agency action contains 3 causes of action. The first, brought under Utah Code Section 40-8-14 sub 6, stating if an operator of a mining operation fails or refuses to carry out the necessary land reclamation as outlined in the approved notice of intention, the board may, after notice and hearing, declare any surety filed for this purpose forfeited. The division will show that Triumph has not completed reclamation work on the subject mine as outlined in a previously approved and now withdrawn NOI as required in its reclamation contract and despite repeated requests from the division to reclaim the site. Because Triumph has failed or refused to carry out the necessary reclamation, the board should declare Triumph's reclamation surety for the subject mine forfeited to the division, specifically an irrevocable letter of credit in the amount of $64,400, which is, as I stated, held by the state treasurer's office for the benefit of the division. The second cause of action is brought under Administrative Code Rule 647-3-112, stating if an operator of a small mining operation fails or refuses to conduct reclamation as required by a complete notice of intention and fails or refuses to comply with rules 647-3, 107, 108, or 109, the board may, after notice and hearing, order that reclamation be conducted by the division. Again, Triumph has not completed reclamation work on the subject mine as outlined in a previously approved and now withdrawn NOI as required in its reclamation contract and despite repeated requests from the division to reclaim the site. Because Triumph has failed or refused to conduct the reclamation, the board should authorize the division to complete the reclamation using the forfeited funds. And the third cause of action is brought under Utah Code Section 40-8-14-6 sub B, stating the board shall request the Attorney General to take necessary legal action to enforce and collect the amount of any liability. Additionally, the Administrative Code Rule 647-3-112.2 provides that the board may authorize the division to recover the costs and expenses of reclamation together with attorney's fees in a civil action brought by the Attorney General against the operator in any appropriate court. Triumph has refused to provide the division with additional reclamation surety despite repeated requests to do so. And because of Triumph's refusal, the division anticipates it may need to take action to recover any costs in excess of the forfeited funds. Therefore, the board should authorize the division to recover any costs or expenses in excess of those forfeited funds. With that, I would now like to ask Mr. Western a few questions. So first, Wayne, can you state your name and spell it for the record, please?
Okay. My full name is Wayne Henry Western, WayneHenrywestern.
And what is your title and position with the division?
I'm a engineer 3 with the Division of Oil, Gas, and Mining.
And how long have you been working with the division?
I started work with the division in December of 1991. I was employed in the coal program, and I switched over to the minerals program in 2008.
Okay. And can you just briefly describe what you do in your current role?
Okay. My current duties are that I am the lead for counties that include Juab, Box Elder, Weber, and Wayne County. Then I provide technical assistance in engineering and reclamation cost estimates. I do inspection and enforcement, and I also do customer service as needed.
Okay, and were you assigned as the inspector of the Gardner Canyon mine?
Yes, when I first came on to the minerals program, I was assigned Juab County, where the mine is located.
Okay, and is the Gardner Canyon mine currently covered by a bond, and if so, how much?
Yes, the bond is currently in the amount of $64,400.
Okay, and just for the board's knowledge, that bond file was included with the division's exhibit filing as Exhibit B. And Wayne, did you conduct an inspection of the Gardner Canyon mine back on August 22nd, 2018? And if so, what did you find?
Yes, I did do an inspection of the mine. The inspection included an on-site visit as well as a review of the paperwork. And as part of the review of the paperwork, I found that the bond was due for escalation in 2018. And based upon the per acre costs, I submitted a notification to the operator that they would need to increase their bond.
Okay, and so can you just briefly explain why was that bond amount insufficient at that time?
And the bond amount was insufficient because when we bond for small mines either 3 or 5 years for escalation. At that point, the escalation period had ended, and we needed to increase the bond based on a new either 3 or 5 year escalation period.
Okay, and what was determined an appropriate bond amount for the Gardner Canyon mine based on that August 22nd, 2018 inspection?
Okay, we gave them the option of either bonding for $90,300 for a 3-year escalation or $92,500 for a 5-year escalation.
Okay, and did you notify Triumph of that required bond amount? And if so, how did the division do that?
We sent a certified letter to Triumph Mining stating that they needed to increase the bond.
Okay, and I'm gonna put some of these exhibits on here. I'll just point them out to you. Just bear with me for a second while I find the right one. And can you see the screen that I'm sharing, Wayne?
Yes, I can. This is a letter dated August 28th, 2018 to Robert Steele and Alan Young with Triumph Mining Corporation.
Great. And that was admitted as Exhibit G. And was there another letter after this letter was sent that went out to notify Triumph?
Yes, there was. We sent out an additional notification letter.
Okay. And is this the second letter that was sent out? This is Exhibit H?
Yes.
Okay. And so this letter shows that Triumph paid a delinquent permit fee, but did not post the increased bond amount. So what was the next step that the division took at that point?
And the next step would be to issue a cessation order that required either the payment of the bond or reclamation.
Okay, and is this Exhibit I the cessation order you just referenced?
Yes, it is.
Okay, and so did Triumph ever provide that bond amount?
No, they did not.
And did Triumph ever reclaim?
No, they did not.
Okay, so what happened instead?
Okay, instead, they did ask for a conference in which they wanted to discuss the facts and also of the violation, also the fine.
Okay, well, I'd back up a little bit first because I think what led to that informal conference and that appeal? What were they appealing?
They were appealing the facts of the violation. Well, they were okay. So we withdrew the notice.
Right. And so is this Exhibit K? Yes. Is this the letter withdrawing the notice of intention?
Yes, it is.
Okay. And so you mentioned the penalty assessment. Is this Exhibit L? Is this the penalty assessment that was issued at that time?
Yeah. Yes, it is.
Okay. And so how did you were discussing this a bit previously, but how did Triumph respond to the withdrawal of that NOI and the penalty assessment?
Okay, they asked for a conference in which they were wanted to discuss the facts of the violation and also the penalty. In the conference, Dana Dean was the officer, and she upheld the facts and also the amount of the penalty.
Okay, but did Triumph appeal the withdrawal of the notice of intention or just the penalty amount?
I believe they appealed the notice of the withdrawal also.
Okay, is this the finding of facts, conclusion of law and order that you mentioned that was overseen by Van Deen?
Yes.
Okay, and so did Triumph pay the penalty amount?
Yes, I believe they did.
Okay, but was the bond amount ever increased or was the site ever reclaimed?
The bond was not increased and the site has not been reclaimed.
Okay, and so after that informal conference, some time passed and there wasn't much activity or communication about the mine. So what did the division do next?
Next, the division issued a directive stating that the mine needed to be reclaimed.
Is this the April 30th division directive?
Yes, it is.
And this is Exhibit P. Yeah.
Yes, it is.
Okay. And so in this division directive, it was requiring full reclamation, and it also stated that regrading must be completed by April 30th. Could you just explain, what is meant by regrading in this directive?
Council, could you please put the April letter up you're talking about rather than just walking through and leading through the whole thing, please?
I'm sorry, I didn't understand what you said.
You asked Mr. Western if he had filed something on April the 30th or something, but you didn't put it up on the screen. And I'd like to see what you were referring to.
Okay, just to clarify, I was referring to that division directive that was sent out on March 5th, which contained that April 30th deadline for getting the regrading completed of the subject mine. So it wasn't an April 30th document, but I was just mentioning the April 30th deadline in that document.
Thank you very much. And so what you're talking about then is the March 5th, 2021 letter.
Correct.
Thank you.
Which is hopefully on the screen. Can you all see this? Okay.
Thank you.
No problem. So Mr. Western, again, I was just asking if you could explain what was meant by the regrading that was to be completed by April 30th.
Okay, regrading would be to smooth out the surface areas so that they would blend into the surrounding areas.
Okay, and so was the mine site ever regraded?
No, it was not.
Were there portions of it that were, though?
The road going from the loadout up to the mine site had been graded or bladed to get rid of some of the ruts and rills that were in it. But that was the full extent of any earthwork that had been done at the site that I could identify.
Okay, and how do you know that?
I did an inspection on May 5th of this year.
Okay, and I'm trying to show, can you see this Exhibit R? Is this your inspection report from that inspection that you referenced?
Yes. Excuse me, it should have been May 6th. Not, yes, I did a May 6th inspection.
Okay. And so how did the inspection go? Maybe there's some images in here I could scroll through here to just show, but maybe you want to discuss what you saw during that inspection, which was after that date when the regrading was supposed to be completed of the mine site.
Okay.
Mr. Lyon, what exhibit are you quoting from?
This is Exhibit R. This was filed I'm sorry, I should have mentioned the exhibits R and S were filed as a supplemental exhibit filing after that April 30th date, because there was the condition to get the regrading done, and then there was a subsequent inspection to see if that work had been performed. And this is that Exhibit R contained in that supplemental exhibit filing. Sorry, I did not clarify that.
Okay. If you could go back a page.
Sure.
Okay. So there are two images. One is just a general outline that we have of where the mine would be located. It is east of the city of Nephi. The second picture is the loadout area. What the mine would do is take material from the pits, truck it down to a loadout area where they would push it over the side of the hill so that larger trucks could come in, be loaded up. They have a turnaround there and then haul off the material, so it would be easier for large commercial trucks to load up there than it would be from the mine site, because the road up there is very narrow and there's very limited opportunity for turnaround. The truck is in the photo for scale. Next page, please. Okay, this would be the topsoil storage area. They do have it marked. There's some cheatgrass there. As you can see, the most of the topsoil is in place. And then the next photo down is an area of the road leading up to the mine. It has been regraded. There used to have a number of rills and gullies in it. Next page, please. These are the pits that are up at the lower level of the mine. As you can see, no backfilling or grading has been done. There's no vegetation or very limited vegetation, I should say, at the site. And then if you go down to the next stage, this is an area where the operator had dump material over the side. It's a very steep slope, angle of repose. There is a little bit of natural vegetation that is coming back, but there are several areas where the vegetation has not yet been established. Next page, please. This would be looking up towards the main mine site. You can see that the area here up top, there's some high walls up there. Again, you can see the outslope has very limited vegetation. Next picture. This is looking to the west of the lower mine site. The trucks are in there for scale. Again, you'll see some steep slopes and no topsoil or vegetation. Next page. This is looking down. There was some area that the operator had dumped material that went off site. This is actually on land owned by the Utah Division of Wildlife Resources as wintering ground. The amount of disturbance is fairly small, and in contact with the DWR, they do not think that it's any substantial damage to the property. Next photo, please. This is the scale of some of the stockpiles. We're up at the upper end of the mine. You can see the high walls, and the truck is in there for scale. Next photo, please. Okay, this is in the upper areas. You can see up on top, there's high walls, very steep pits, walls. No vegetation has been established. Next picture, please. Again, another look up at the upper pit, that you can see that there's some stockpiles, steep slopes, and there's a little bit of vegetation that has come in naturally, but it would not meet our standards for bond release. Next picture, please. Again, this is up on top by the high walls. We're looking down at the pit, and you can see the scale with the truck. So that's the end of the inspection report. Any additional questions?
I don't have any additional questions for this specifically, but I wanted to point out another Exhibit S that was included in this supplemental filing. It just includes some before and after pictures. Wayne, were all these pictures taken by you in previous inspections and then at this current inspection that you just did on May 6th?
Yes, they would be.
And this is just depicting what the mine site looked like in similar images historically, and just showing the current state of them. So
correct.
I just wanted to point that out for the board. That is in Exhibit S as a part of that supplemental filing. So I'm just going to continue to ask you a couple more questions, Wayne. So did Triumph ever contact you or the division before that April 30th date to discuss the regrading or what was expected?
There was not, no, they did not.
Okay. And so just a couple of follow-up questions. So Triumph filed a response to the division's notice of agency action. In that response, they state that there was efforts made to reseed and reclaim significant parts of the 10 acres. This is in the statement of facts, paragraph 15 and 16. Are you aware of any of the reseeding efforts or the effort to reclaim significant parts of the mine as alleged in that response?
I have no direct knowledge. I have heard reports that Bob Steele had gone up and spread seed over the outslope area, but there's I never saw I was never officially notified of it, nor did I see any seed tags or other things that would indicate what type of seeding was done or when.
Okay, and so I mean, what are operators supposed to do before they conduct reseeding?
Okay, they should use an approved seed mixture. That mixture can either be from the division or it can be from a sister agency, such, in this case, it's, Forest Service has jurisdiction in the area, so they could receive an approved seed mix from them. They would also generally want to notify the division of when regrading would take place so that we could have the opportunity to have staff on site to evaluate that so that we could make sure that they were doing it in accordance with the plan, so that the last thing we want them to do is a lot of work and then for us to come back and say, sorry, you didn't do something right.
Right. And so, I mean, did Triumph ever contact the division to get approval for a seed mix or explain that there was going to be a reseeding done?
No, they did not.
Okay. And also in Triumph's response, statement of facts in paragraph 17 states that only limited parts of the approved 10 acres which have visible gypsum deposits have not been reclaimed. So based on your inspection, would you say that is an accurate statement?
Most of with the exception of the roads, the site has not been reclaimed.
Okay. The Triumph's response also states that the reclamation of visible gypsum would cause irreparable harm because the material could be destroyed or significantly devalued by contaminating soils. is this an accurate assertion in your opinion?
No, it's not. The material that would be placed over the gypsum is naturally occurring material that was over the gypsum originally and had been removed as overburden. And gypsum is fairly stable, and I'm not aware of any things within the overburden that could cause the gypsum to deteriorate in quality.
Okay. And then also in the response, Triumph has stated that there's a new mining company preparing to take over the mine, asserting that a notice of intent has been or will be filed before this hearing. Has the division been contacted by or know anything about another mining company preparing to take over?
Not to my knowledge.
I will say, I'll add that Triumph did file that supplemental exhibits last night with a statement from, I believe, Mr. Birmingham saying that they were interested, but nothing, Wayne, to your knowledge, nothing formal had been filed, a notice of intent or anything.
No, in order for that to occur, they would have had to file a transfer, and they would have had to also file a new notice of intent.
Okay. And so just in sum, just a couple quick questions at the end here. We already said a new notice of intent was never filed, but in your opinion, has Triumph failed or refused to conduct the reclamation as required in its notice of intent?
Yes.
And in your opinion, has Triumph failed or refused to conduct reclamation as required under division regulations and the Utah Mine Reclamation Act pertaining to reclamation practices?
Yes.
Great. And then, Mr. Chairman, that is all the questions that I have for Mr. Western. I would like to move to have division's exhibits entered into the record, if now would be an appropriate time to do that.
Well, I'm glad you asked. I may have missed some of them, so if we could go through the list of which ones you're offering, that would be
Yes. The ones that discussed with Mr. Western would be B as in boy, G as in girl, HIKL, and I'll slow down if I'm too fast for you, but M as in, I don't know, Mr.
Mr. Lyons, when you identify the exhibit, would you identify, rather than a letter, what it is, like the March 5th, 2021 letter, or a picture of the mine site, so that I can examine Mr. Western with regard?
Sure, I can. If that's helpful, I can do that.
Thank you. It would be very helpful.
No problem. Okay, so once again, Exhibit B, which is just the bond file, bond information and documentation. Exhibit G, which is the division letter from August 28th, 2018, requiring an increase in reclamation surety. Exhibit H, which is a second division letter acknowledging receipt of a delinquent annual permit fee and an additional notice of requiring reclamation surety, dated September 24th, 2018. Exhibit I, which is a citation for noncompliance, citation number MC 2018-42-10, dated October 18th, 2018. Exhibit K, which was that withdrawal of the notice of intention to commence small mining operations, dated December 19th, 2019. Exhibit L, which is the proposed assessment for cessation order MC 2018-42-10, dated December 23rd, 2019. Exhibit M, which was the findings of fact, conclusions of law and order from the informal hearing, dated June 5th, 2020. Exhibit P, which is the March 5th, 2021 Division Directive to Reclaim. And then also the division filed the supplemental exhibits, which was Exhibit R, and that is Mr. Western's inspection report from, was that May 6th? And then Exhibit S, which was also filed in that supplemental exhibit filing, which just shows some before and after pictures that were taken from inspections. And those would be the exhibits that were discussed and what the division is moving to have entered into the record.
Okay. So Mr. Lyons, you're not asking to admit Exhibit A, C, D, E, J, N, O, correct?
Correct. We did not discuss those during this this hearing, but they were offered as historical context for the purposes of the notice of agency action.
Okay. Thank you.
Mr. Chairman?
Yes, Ms. Carter.
When you reiterated the exhibit list, I didn't hear you mention Exhibit Q or Exhibit F. Did I miss those?
Oh, yes, Q was not included, but S was.
F like Frank?
I'm sorry, did you say F or S as in
F.
Sally?
F like Frank.
Sorry, F like Frank was not included.
Thank you for the clarification.
And F, Mr. Lyons, F as in Frank was not included, correct?
Correct.
I don't understand that.
Why it was not included? Was there a reason, Mr. Lyon, that you did not include Exhibit F, which is the citation for noncompliance? Dated August 2nd?
Right. Sorry. So that was a delinquent permit fee that was issued around the same time as the reclamation, the cessation order for increasing the reclamation surety. For purposes of Wayne's testimony, we just focused mostly on the fact that the reclamation has not been conducted and that the bond amount was never increased. Those are just kind of peripheral violations that were in the historical context for that notice of agency action and not absolutely hinging on whether or not these requests that we're asking the board today should be granted.
Okay, thank you. I understand. Now, typically, in our process, we will turn the time over to Mr. Young, and then after that, the board will have an opportunity to ask questions of Mr. Western when Mr. Young is finished. So at this time, why don't we go ahead, Mr. Young, and let you well, I guess the question has been asked, do we want to wait until after lunch? Or Mr. Young, how long do you believe your questions of Mr. Western will take at this time? I believe you're on mute.
Thank you. I am happy to start. It will clearly be longer in my view than 15 minutes. It will be more like a half hour to 45 minutes.
Well, in that case, we'll take Ms. Davis's suggestion and we'll break now for lunch. And when we come back, you can ask your questions. The board will ask their questions, and then we will turn the time over to you to give your presentation. So this seems like a good point to take a break. We'll do so. We'll reconvene at 12:45. Okay, 1 o'clock. And we will go off the record and return at 1 o'clock.
Thank you.
Thank you. Okay, we're ready to re-adjourn. Let me make sure that Michelle, the court reporter, can hear me all right. All right, I got the thumbs up. We've got the board members back online. So we will go back on the record when we left for lunch. We had left at the end of the testimony that was provided by Mr. Wayne Western, and Mr. Young wanted to address some questions to Mr. Western. So if you, Mr. Young, if you'd like to go ahead.
Thank you, sir. Mr. Western, can you hear me?
Yes.
Okay, thank you.
Can everybody hear me?
Yes.
Yes. Thank you. Mr. Western, I'd like to lay out a little history with you, just for background purposes. I'll try to keep this part of my examination of you brief. You are aware that either Bob Steele or folks he is related to have owned the Triumph claims. They are a patented mining claim. There are 60 acres that were patented way back in 1950s. Are you aware of that?
I am aware that there are patented claims up there. I don't know how far back they go, but yes, I am aware that they're patented claims.
Thank you, sir. And at least they go back further than the 90s when you became the representative for Juab County on minerals. Is that correct?
I believe so. On the dates, I'm not. I can't verify the dates, but I do believe that they are patent mining claims that have gone back in time for some years.
Yes, and with the patented mining claims, these mining claims are what some folks refer to as a split estate. Is that correct? The Forest Service owns the surface, and the owners of the patent mining claims, which is now Triumph Mining Company, own the mineral rights below the surface. Is that a fair statement?
Believe it is.
Thank you. And that's been so for the period of time since the 90s when you've been involved. Is that correct?
Okay, I wasn't involved with Juab County in the mineral program until 2008. I was in I worked over in coal from 1991 to 2008. So I have, I've looked a little bit into the history of it, but I really didn't come on the scene until 2008.
Okay, thank you. And that was my next point. You have looked into the history. You're aware that there has been fairly significant litigation over those mine claims over the years, are you not?
I understand that there were some court battles that were fought between Triumph Mining and the federal government. Involving, I believe the issue was over wilderness, but I'm not sure.
Yes, I would represent to you that that's how I got involved in this, is that the mining claims were at one time determined to be a wilderness area back in the early 2000s. And then after a court of claims battle, it was determined that they certainly were not untrammeled by man, and Congress actually released them from the wilderness designation. Did you become aware of that?
I am aware of that the claims are outside of the wilderness boundaries.
Okay, and did you know that they used to be in the wilderness boundaries?
Yes.
Thank you. So since 2008, when you've dealt with them, you have had more than one conflict with Bob Steele or the predecessors of Triumph. Is that true?
I haven't dealt with anybody besides Triumph Mining, and I'm not quite sure what you mean.
Okay. You've had a lot of conflicts. You've suggested fines to Triumph for things as little as allowing tires to remain on the mining claims. Is that correct?
Is this with regard to Gardner Canyon?
Yes.
See, I'm not sure on that, but I know I have written a few violations on Gardner Canyon.
Okay, thank you. Now, and up to and including, and let's get more specific about what's really relevant and important to the folks here today. In 2015, a bond was set, and the Clyde companies, or Rock Creek Gypsum, met that bond of $64,000. Is that correct?
I'm not sure who was holding that bond at that time, but we did post for 60. There was a bond for $64,400.
Yeah, and that is an amount that had been set by the Dogum to mine those claims. Is that correct?
Yes.
And then in August of 2018, you were aware that the Clyde companies quit mining those claims in 16 or thereabout. Is that correct?
I'm not sure what you mean by mining. They were not the permittee. They were acting under the direction, they were a subcontractor. So the permit would have been in Triumph Mining's name, and they would have been responsible for having the permit, the bond, and also the reclamation contract.
Okay, that you may be correct. I don't know all of the ins and outs of that. I thought it was in the name of Rock Creek Gypsum that the bond was formulated. But you were aware, were you not, as the representative here, that the Clyde companies were mining those claims?
Yes. Okay. I was aware that there was an agreement between Triumph Mining and the Clyde company to mine the claims, but Triumph was the permittee.
Okay, thank you. I believe there was never an agreement between Triumph and the Clydes, but that's not relevant here today. The fact is the Clydes were mining them, and it was the Clyde companies that spilled material over the top onto state lands and into the other area you talked about, the state Division of Wildlife, or is that correct? Was it your information that the Clydes did it?
That they were the company that was mining at the time. Yes.
Right. And you cited Triumph for that, and that was all resolved either through a meeting with you or fines or the combination of all of those things. Is that correct?
Correct.
All right. And then in August of 2018, you meaning Dogum, unilaterally increased the bond. Is that correct?
We did so in coordination with the Forest Service.
Yes. Now, did you coordinate at all with Triumph Mining?
No, we didn't. We sent out, at the time, Triumph was working on a per acre basis. And so we sent out a notice that on what the increase would be on a per acre basis. Triumph Mining does have the option to calculate out a bond based on a detailed reclamation plan, which they did not.
Okay. Did you advise Triumph Mining that we had the right to sit down with you and detail a plan? And if in fact the bond amount would be less, the state would go along with it? Or did you just unilaterally impose the increased bond?
I believe that we did mention that they did have the to Bob Steele. There would usually be an opportunity for them. It is in the rules, specifically in the rules, that they have the opportunity to do so.
Yeah. Do you have anything in writing to my friend Bob Steele or to me as an officer of Triumph Mining that we have the right to do that?
No.
And you would agree you didn't do that. You didn't call me on the phone and say, Alan, you have the right to have an engineering outfit see if this amount of money is fair for that project. Is that true?
That's correct.
And
I did not send. The division did not send anything specifically in writing.
Right. You just unilaterally increased the bond.
Excuse me for a moment. Just, Mr. Young, are you going down the path that that you as a representative of the mining company were ignorant of the mining rules? I mean, the small mining rules are fairly well spelled out as to what can and can't be done.
Yes, sir. I think that I am ignorant as to those mining rules. Bob Steele is 85. He owns 33% of this mining company. This mining company has kind of been a family mining company for a long time. Gene Danzy is 90 years old. I'm 75 years old. And we've tried to accommodate the rules as best we can. We've you're aware, Mr. Western, that we've tried to sell this. Is that correct?
I've heard reports that the attempts were made to either sell the claims or have another company come in and be the operator.
Okay. And so, sir, to respond to your question, and I apologize, I didn't see your name, but the answer is no, I didn't know we had the right to object to the amount that they listed until recently, until last year when we spoke to a mining engineer that said we could do that. But you didn't give us the opportunity to do that, did you, Mr. Western?
You specifically no. If you're saying that we didn't inform in writing, but I do believe Bob Steele has had a lot of experience in mining, and that there are other claims that I have worked with Bob Steele, and I know that he was aware of the opportunity to come up with detailed reclamation costs that could be used for the bond on other projects. So he would have been aware that was a viable option in this case. Specifically the Nephi Gypsum and also the Coyote Knolls project.
Okay, those were negotiated bonds?
We gave them the option at that time, and they specifically, we gave them the option at that time for the Nephi Gypsum, which is just a few miles south, that we could either use a detailed reclamation cost, or we could use a per acre basis, and Bob elected to use the per acre basis on the Nephi Gypsum. So he would have been aware of those options, and the same thing on some of the bonds for the Coyote Knolls project, which is out in the West Desert.
Okay.
So
I'd like to jump forward, Mr. Western, and the new bond was set. Is that correct? The 94.
The bond, we gave the option of 90,300 or 94 on a 3 or 5 year basis, according to the rules.
And you were aware that no mining was going on during these periods of time. Is that correct?
I inspect the site once a year, so I can't always be sure of what mining was occurring, and we do rely on annual reports.
Yeah. And
so there was the annual report for 2019 said that there was no mining at that time.
Okay. And since you visited the site in 17 and 18, you would clearly know no mining was going on. Is that correct?
It depends on how much mining was going on. There's some mines which, you could only, you could pull out a couple of truckloads and I wouldn't know.
Okay.
So I can't specifically say that no mining occurred. I don't think any major mining had occurred at those times.
Okay. Thank you, sir. So jumping forward a little bit, in 2020, my son Tyler and a mining engineer, Bryson Hinkins, and Bob Steele's son, Brandon, met with you and representatives of the Forest Service at the mine site. Is that correct?
Yes.
And part of the reason for that meeting was to discuss the reclamation of the road because the parts of the road up to the mine site had washed out. Is that true?
Yes.
And also, isn't it so that with regard to the mine, Mr. Young and Mr. Hinkins represented to you that it was their plan to file a brand new notice of intent to mine the property if it couldn't be sold?
They mentioned that, yes, they did mention that they might be interested in purchasing it or that they were looking for potential buyers.
Thank you. And at that meeting in June, is it also correct that the Forest Service, through Mr. Luke Decker or others, Mr. Rozier, indicated that since this was a split estate, in other words, the federal government owning the surface and Triumph Mining owning all of the valuable minerals under the surface, that they might be or would be interested in acquiring that estate?
I'm sorry, I don't recall. There was a lot of things going on. I don't recall all the specific details about that. So in fairness, I can't say yes or no, in all honesty, under oath.
Okay, well, that's, ladies and gentlemen, I sent over the lunch hour a new proposed exhibit. May we show the witness that exhibit? It would be our Exhibit E.
In the interest of fairness to the division, I don't believe we'll allow that exhibit into these proceedings. I mean, we allowed the one from last night, but during the hearing itself and submitting exhibits that don't allow the division enough time to consider and include in their argument, I don't believe we're going to admit that at this time. However, my guess is you've covered most of the issues that are in it. So,
well, no, he said he doesn't remember whether there was talk about selling, and that's a critical issue in that document.
I guess from my position, I don't see the relevance there. So I'm not inclined to allow it to be entered at this time.
Mr. Chairman, if I could interject with just something that may be helpful. We do have Luke Decker, who is with the Forest Service, participating in this hearing. And if some of these questions and concerns that Mr. Young are being brought up with trying to sell the mine to the Forest Service, he may be available to help clarify any questions with that, if that's helpful, if the board would desire so. I just wanted to point that out, that he is also participating in today's meeting and available if needed. And that's all I wanted to say.
And Brandon Steele is going to testify as well. So I'll move forward.
Okay.
I'll move forward. You would understand, would you not, Mr. Western, that if a company were going to mine this, their actions would be different than if the federal government was going to buy it and it would be reclaimed, would you not?
I'm not quite sure I'm not quite, okay, if you're saying that if a company was going to buy the mine and mine it, what they would be doing is different than if the Forest Service were to buy the land and reclaim it.
Yes, sir.
They would, their intentions would be different, yes, but eventually the mine would have to be reclaimed.
Yes, or you would agree if a company mined it. Have you information that there are 3 million or more tons of gypsum in that mountain?
I know there's a lot of gypsum up there. I can't testify as to the amount or the quality or the economics of it.
Okay, and it would just be different, wouldn't it? If the government bought it, they'd want to buy it to just make it a part of a Forest Service area. At one point was even wilderness, rather than allow mining for the next 40 years to extract all of that valuable gypsum. Is that correct?
I don't know. They could lease the claims out to somebody to mine them. That would be an option. The federal government does allow companies to come in and lease gypsum, so I can't rule that out.
Okay, thank you. And let's jump right to a very important point, in my view, at least, right here now. You have testified today under oath that you don't believe it would be irreparable harm to that gypsum to have it reclaimed and then a new company have to come in and try to extract it in a reclaimed state. Is that your testimony?
Yes.
Okay. And now let me ask you this question. If this bond is forfeited and you get the $64,000 prize,
yes.
Excuse my insulting the way I ask it, and I apologize. If the state is awarded that $64,000 and they expend that to reclaim all or parts of that mine, and a new company comes in and files a notice of intent, they'll have to file a brand new bond for the same or similar amounts of money. Isn't that true?
May I make a comment here? Forward-looking doesn't make any difference. We are talking about what is going on right now. So would you please address issues that are happening right now? We don't know anything about people buying it in the future, and it's irrelevant. We're talking about notices that occurred in 2018, and we're talking about things that happened in 2020. We're not talking about things that are going to occur.
Well, with all due respect, if the bond is begun to use to reclaim that and a new notice of intent is filed, that money would be irreparably lost.
That money is part of your bond and it is already in forfeit.
Okay.
We're not talking about who might do what in the future.
Well, I personally think that's very relevant, but I'll move on. Okay. So after the meeting in 2000, last year in 2020, the June meeting, you would agree it was on June the 12th or thereabout of 2020, Mr. Western?
Yes.
Okay. Nothing occurred with regard to the mine. You didn't read any letters that say the Forest Service wants to buy the mine. Is that correct?
That's correct.
And you didn't have any further talks with Bob Steele or me, or you didn't write me any letters until March the 5th. Is that correct?
Yes, that is correct.
All right, thank you. Mr. Lyons, could you pull up Exhibit P so that the witness can see it?
Sorry, I was muted. I can. Just give me a moment. I understand you're probably still waiting for me. I wasn't prepared to share my screen.
I'm
again.
sorry that I
Sorry.
didn't give you advice.
Yeah. Okay, can you all see the screen? This is Exhibit P. And trying to get all the, there, that's the meat of it. Let me know if I can be of any more assistance.
Thank you very much. And Mr. Western, although Mr. Baker signed this letter, you were one of the persons who authored it. Is that correct?
I just a second. My phone, I'm trying to mute my phone ringing in the background, so it doesn't disturb. I was involved in drafting the letter, but it did go out under the signature of Paul Baker.
Yes. And now this is the next communication with anybody from Triumph Mining, whether it be my son, Mr. Hinkins, Mr. Brandon Steele, or Bob Steele. This is the next communication after the June meeting of 2020. Is that correct?
I believe so.
And your under oath testimony is you don't recollect there being a conversation about the potential for the federal government's wanting to buy it, which would then require reclamation, versus my son mining it?
The conversation happened in 2008.
No. 2020.
There was a conversation there. I don't have notes for it. There are a lot of things were discussed. If you're asking specifically about the Forest Service wanting it, I don't remember all of any details that were involved with the Forest Service. If there was conversation, if you mean did the Forest Service make a legitimate offer at that time, I can testify no, they did not.
Okay. And I think they have not done. So thank you. So your next action was this March 5th letter. Is that correct?
That's the division's next step, yes.
Yes, and and the letter of March the 5th, 2021 requires full reclamation of the Gardner Canyon mine. Regrading must be completed by April 30th. That would be some 50 days after the date of this letter. Is that correct?
Yes.
Yes?
Yes.
And you were aware that in March, nobody's going to get up Gardner Canyon because of snow, or likely not going to get up to Gardner Canyon because of snow.
This year we had a fairly mild winter, and know that when I went up for the inspection that there had been some road work, so people could have gotten up there and done some mining. And there was, so yes, people were able to get up there, do some reclamation before the deadline.
No, I agree totally with that. And we're going to get into the days on that. But as of March, do you know what the condition was that a person could even get up to attempt reclamation?
I've driven by this a couple of times. I've driven by the site, and it seemed the snow had melted off. So I had access to the canyon, as you know. There's a lock gate there, so I wasn't aware. I can't testify exactly how much mud or snow was up there, but there was no follow through from the operator asking for additional time.
Okay. Now, were you aware? So you believed it was reasonable to require the regrading of the whole mine site in 55 days?
Yes.
Is that correct?
Yes, I'd say you could probably do it within a week or so.
Okay. And then you also put in the letter that you require the preparation for seeding must be completed by October the 31st of 2021.
Yes.
So even according to your letter, the efforts to seed aren't required to be completed until October. Is that correct?
Yes.
So you had in this letter, unilateral, you didn't talk to me or Mr. Steele or Mr. Brandon Steele or Mr. Tyler Young or anybody else about, hey guys, let's meet up there and get this thing taken care of. Is that true?
I believe at this time we had run out of options, and this was our last opportunity to either have the site reclaimed or go for the forfeiture of the bond.
Okay, now when you say we'd run out of options, you had your meeting in June of 2020, is that right?
Yes.
What other communications did you have, either by phone or text or email, with Mr. Steele or me or anybody saying, hey guys, let's meet some more and see if we can agree either on a mine plan or to get it reclaimed? Any communication whatsoever?
I don't recall any phone calls, but I'm not aware of any efforts by the permittee to make contact with the division and ask for an extension.
Okay, and it was your understanding that the regrading, I think you testified just now, that the regrading in your view would take maybe 4 or 5 days?
I would say up to 2 weeks. Could take a week to 2 weeks to do it.
Okay. Did you know that the complaint for the forfeiture of the bond, the notice of agency action, was commenced prior to April 30th of 2021?
I'm not sure on the dates on when that happened.
Well, if the agency action,
I don't. Okay, I don't have that document up in front of me with the specific date. So that's why I'm saying that if you want, I would have to look at the document to know the exact date on when it was filed.
Okay. And and I'm looking at this first sentence here. The Division of Oil, Gas, Mining requires full reclamation of the Gardner Canyon mine. Regrading must be completed by April 30th, 2021. We've agreed that's 55 or so days. You were aware that there had been discussions in June of 2020 about regrading the road. Is that correct?
I'm aware that there were talks about regrading the road because it was in very poor condition. It was next to impossible to get a vehicle that's licensed to drive on the highway up there. You'd either have to hike or take some type of an ATV to get up there. The road was in very poor condition.
Okay, thank you. And I appreciate that answer. And for the board who may or may not have ever been there, there is a gate on a Forest Service fence and then a road for about a half a mile up to the mine site. Is that correct? Mr. Western?
Yeah, yes, there are a couple of gates, and then you come to a Forest Service gate that is locked, and at that point you need special permission to enter. So for the general public, they would only be allowed to either enter on horseback or on foot. Any other type of vehicle access is denied except for the mining related.
Thank you. I appreciate that answer. And so the conversation in June of 2020 dealt with regrading that road, didn't it? It needed to be repaired and upgraded, whether it was going to be mined or whether it was going to be reclaimed.
The road would need to be the road needs to be maintained, and so the answer to that specific question is yes, the road needed to be maintained.
Okay, thank you. And would you agree with me that before April 30th of 2021, Mr. Steele or someone, and Mr. Birmingham or someone regraded that road?
All I can say is the road, I was up there on on May 6th, and the road there was evidence that the road had been regraded, so it must have been sometime before that in the spring of this year.
Okay, thank you. And you didn't call me or Mr. Steele or anyone else to say, hey, I'm going to go inspect to see if the requirements were met so we can talk about them and see if I'm satisfied, because in this letter it says this matter will be stayed if you get the regrading done. Is that correct?
It would be the regrading of the site.
Yeah, and it doesn't say that, but yeah, I'll agree that that's what you were saying at that time. But the road was regraded prior to April the 30th, or before you went there. Is that correct?
When you mean by do you mean regrading in the sense that the road was reclaimed, or do you mean that the road was repaired to allow for vehicle access?
I mean the road being repaired for vehicle access.
Yes, the road was repaired, maintained for vehicle access, that you can easily take a a four-wheel drive street legal vehicle up there. Well, before it was very difficult.
Thank you. And that was what the discussion with Mr. Decker and others was about in June of 2020, is to get that regraded so traffic could access it. Is that correct?
Among other things, yes.
Okay, thank you. Now,
Mr. Young?
yes.
Mr. Young, this is LaVon Garrison. I just had a quick question. Did any representatives of Triumph, when they got these various notices from the division, contact the division to discuss possible settlements, possible, how to bring it into compliance? And do you have any dates that you actually contacted the division?
Yes, we have emails to Mr. Decker and the BLM about wanting to meet them there to talk about all of this on April the 2nd. Immediately after getting this March letter, Bob and Brandon Steele and I became concerned, and we wanted to work with folks in terms of getting it reclaimed or getting it regraded and then a notice of intent filed. And so, yes, Brandon Steele sent an email, which was admitted into evidence this morning. Brandon will go over it with you, where he asked to meet with these folks starting on April the 2nd, and no one ever responded to him. And that's our exhibit. I think it's G, but I'm not sure. It's EF or G, I believe. And we did that. There's screenshots of our attempts to meet folks up there to try to work it out with them in order to try to resolve this thing. Nobody would respond to us.
Thank you.
Mr. Chairman, may I interject to clarify Ms. Garrison's question for Mr. Young?
Yeah, go ahead.
Okay, I just wanted to clarify because Ms. Garrison asked if Triumph had made any communications specifically to the Division of Oil, Gas, and Mining. However, Mr. Young was stating that he made contacts with BLM and various other federal agencies. But Ms. Garrison was asking specifically if any communication was made to the Utah Division of Oil, Gas, and Mining.
Mr. Lyons, I will let Mr. Steele speak to that. He is the one that was taking charge and trying to get a stipulation worked out with them. And I don't know whether Mr. Western was CC'd or not. Mr. Western, do you recall being advised of attempts to meet with the Forest Service folks that had been there in 2020, Mr. Decker and Mr. Rozier and others?
No, let me just, let's see. I'm just checking my
Let me
emails.
interject here for just a minute. We do not have exhibits E, F, or G from Triumph. So please don't refer to them.
I believe this morning they were accepted by Mr. Lyons without objection.
We have B, C, and D. We do not have E, F, and G.
Can you tell me what B, C, and D are?
B is some photographs, C is a letter from Gary Birmingham, and D is screenshots.
Okay.
We do not have E, F, or G.
So the screenshots is what I'm referring to. It's those screenshots. So that is what? D? So may I refer to them, please?
All right. Mr. Young?
Mr. Western, there's not a question before you right now.
Okay.
Mr.
May I
Young,
proceed?
hold on just a minute, please.
Yeah.
We do have another matter to consider today, and perhaps it would be helpful if we could move this along a little bit. If you could get to the heart of your argument. I understand what you're doing in your questioning of Mr. Western, but we're starting to, I think, ask questions and refer to issues that we haven't really had a chance to discuss. Materials that you've submitted. Can we just get to the heart of where you're going with Mr. Western as quickly as possible?
Sure, I can jump right to the end if you would like.
That'd be great.
What we would like is to sit down with the federal government again and Mr. Western again and meet them and see what needs to be done by October if there isn't a new mine plan in place before then. Because they gave us until October to get it reclaimed. And we did what we hoped to be able to do to get that road regraded to meet the requirements of the Forest Service so that we could then go about either then getting a new mining permit installed or getting the thing reclaimed by October. And in light of all of this, even though we believe we had reclaimed the road, which was regraded road, which was our obligation, before the 30th ever occurred, we were sued with this notice of intent, and we were required to respond immediately, and then are told that the October date is no longer relevant. And we would love this thing to be continued out 60 days or so to try to work it out with Mr. Western and Mr. Decker and see if we can't. It is now our plan to file a new notice of intent to mine. And it's our argument that if the bond is forfeited, that money will be irreparably lost, either by covering up our gypsum or because a new bond will have to be placed with the new mining company. And it can all be resolved before October, I believe.
So you're asking the division to meet with you and the Forest Service and have a hard set deadline in which either the mine will be sold or it'll be reclaimed.
Sold or a new notice of intent will be filed and replaced, or it will be reclaimed.
Okay.
And
so
we think October 31st, the day we were given, is a reasonable date.
Well, I think if you look back at the history of this, they gave you a date in April to complete the dirt work, or the work required to reclaim the site to approximate original contour as much as possible, or whatever your plan requires, and then to have it reseeded by October, which is typical for revegetation efforts under the rules, I think, that govern reclamation. But I understand if you're not familiar with the rules or how things are done, that you might have considered October being your deadline for completion of reclamation. But I think that the division was saying you needed to be done with your dirt work by the end of April, and then you had until October 31st or a date in October to do the seeding. Now,
yes, sir.
I may be wrong on some of that, but that's how I understand it.
No, I think you're analyzing it well. You understand the catch-22 we were in. If a new mining company comes in, those roads on the mine are important to the mining process. If we sold this property to the federal government or someone else, they may not be important, but they would be important to any mining company in a subsequent notice of intent. So we wanted to get the road fixed before the 30th.
Okay, I understand.
There's a hand.
No, I'm sorry, I don't see anybody on our Okay, Mike.
Hey, Grant. Mr. Chair, I don't know if we're to the point we can ask Mr. Young questions, but the fundamental question I have right out of the chute is, Mr. Young, why hasn't the mining company complied with the division's order to increase the bond amount?
Don't have the money, would have to put our own funds into it. If a new mine plan is formulated and that is found to be a reasonable amount, it'll be put up.
So, Mr. Young, how would you propose that the division covers the cost of reclamation if you choose to walk?
Mr. Brandon Steele is going to testify that the regrading of those roads and the reseeding, if that were done, would cost between $20,000 and $30,000. And that's the kind of conversation that we would like to have with the state to see if we can't come to an agreement if it isn't mined again. It's our full intent that it be mined.
Mr. Young, this is Richard Gordon, also on the board. You do realize that the recontouring is not just the roads; it's the mineral waste rock stockpiles. It's some of the high walls. All of that factors into the bond cost, and some of those earth moving requirements are much more substantial than just road work.
We would be happy to sit down with the state, and if we could agree on a number, and I apologize to all of you for not being involved in the mining business and being a lawyer and not knowing that we have the right to object to that. That's my negligence, but we're willing to try to reconcile that by sitting down with the state and the federal government and coming to an agreement on a bond, which then we'll find a way to meet, or we'll get a notice of intent filed by a company that will meet it.
And you think that's a reasonable risk for the citizens of the state of Utah to take?
Well,
because if you default on this reclamation, that burden is borne by the citizens of the state of Utah via the division. And it's our responsibility as a board to make sure that doesn't happen to the citizens of the state. So I'm not particularly impressed with your argument, Mr. Allen, be honest with you.
I'm hearing this. Triumph Mining could go bankrupt and there'd be 64,000 collected. I'm saying to you that we'd like to sit down and negotiate to protect the citizens of the state and come up with more money on a bond if we have to, or the new mining company come up with an additional bond if that is reasonable. Mr. Western has testified that he just picked a number per acre or something and didn't really assess the cost of reclaiming that whole mountain.
Well, I think in Mr. Western's defense, he was following the rules on how bonds are calculated for small mining operations. But just one thing, and maybe we should be able to move on. The reason I think we're here today is that the division felt like Triumph was not being responsive, and that the final tool left in their bag was to get the bond forfeited to get the work done that perhaps was not communicated, or because of the lack of communication was not occurring. So I think we're here today because there hasn't been proper communication, and we're a little bit leery of the fact that now you're asking the division to allow you more time to negotiate. And obviously, we would need to make a decision on the merits of what you're proposing. And we're not going to do that right now. But I think that perhaps the best thing to do is maybe terminate the questions, I think, if you're done with Mr. Western, and if there are no other witnesses for the division, then we could, and there are no other questions from the board for Mr. Western, then we could allow you to go ahead with your portion of the presentation. Board members, do you agree with that approach? Mr. Young, is that all right with you?
Well, no, sir, it's not. I'm making a record. I have a right to appeal this, I'm told. And,
Yes.
I'm getting down to some of the more relevant questions with Mr. Western, I think.
And they're,
I pretty much covered them, but I can't say that I've covered them.
and they won't be, those issues will not be addressed in your witness's testimony or your presentation?
Well, I would think they would be covered in my witnesses. If we can take a break for 5 minutes, let me study my notes, and then I can represent to you that Mr. Brandon Steele can cover all of these.
I think that would be fine. If we can figure out how to expedite this and get everything that you want on the record, but at the same time recognizing that we want to be as efficient as possible, that would be great. So if we can go off the record and come back on at 2:05.
Thank you.
Okay, I think we're about ready to go back on the record. Let me check to make sure the board members online have come back. I see Mr. Borden is present. Mr. Church is present. I see Mike's avatar.
Well, it should be showing me. I'll try again.
Well, we can hear you. So that's the important part, as long as we can hear you. Michelle, are you ready to go? Great. All right, we will go back on the record, and we have a hypothetical proposal to make to the parties that two things. One, we would give, the division would give Triumph 60 days to negotiate a solution to this, but that the bond increase would have to be posted fairly soon, within a matter of days or whatever the division would like. But the 60 days would allow Triumph to either move forward with their three options after the bond amount, the correct bond amount was posted. And but the 60 days, at the end of the 60 days, if Triumph was not able to satisfy any of the three options that they're trying for, then the bond would be forfeit. We haven't had a chance really to discuss that among ourselves as board members, other than the two or three that are here in person. Board members, I guess maybe I should ask Mike, Steve, and Rich if that sounds like something that we can propose to Triumph.
This is Rich Borden. I could agree to that. I do think it's important that we get the right bond in place, though. As Mike pointed out, we do have a responsibility to the taxpayers of Utah. And I just want to remind everybody, because we may have forgotten with all those peripheral questions we just heard, the core of this is back 4 years ago almost, the bond was increased to account for inflation, perhaps also for an increase in disturbance, and nothing has happened. That's a long time.
Yeah. And this would also allow Triumph to propose a bond based on an outside engineering firm's recommendation that the division could then accept or reject. That is an option that's open to them within that 60 days, I guess. Well, actually, maybe it wouldn't be. No, it wouldn't be. It would be, they would have to post the bond up to the required amount immediately. Haley?
Chairman, this is Rich Borden again. I think we should remember also, they could do the work themselves if they feel it could be done much more cheaply and get the bond released.
But they still have to post the bond.
Right, but as you said earlier, they'd have to post the bond. They'd have to post the amount of the bond as quickly as the division would like.
Completely agree.
Surety was due November 15th, 2018.
Yeah, right. Haley, you got your
I'm
hand.
sorry, if Miss Davis is wanting to be on the record, I didn't hear that.
I'm sorry. The increase in the surety was due November 15th, 2018.
So Haley, there's something you wanted to tell the board?
Yes, thank you. So it is true that the that amount would need to be increased immediately, but Triumph could still get that outside engineering reclamation costs done, and if the amount is something that is acceptable to the division, that the division agrees with, if the bond amount posted is in excess of that amount, then the division could then refund that back to Triumph. So if Triumph really feels confident that the reclamation amount is excessive, then they would only be out that amount for a short period of time until they were able to get us what they think is, and what an engineering firm thinks is a more accurate estimate.
Okay, so what I hear you reiterating is that the bond should be posted to the amount that was requested in August of 2020, right? No, November. Okay, and that if an engineering firm came in with a reclamation amount that the division agreed to that was less than that, then you would refund that amount of the bond.
Actually, the bond letter was 8/28/18, and the deadline was November 15th, 2018.
Okay, November 15th, 2018. And what was the amount?
For a 3-year escalation, 90,300, which is, I'm assuming, what they would agree to, rather than the 92,500, which would give them a 5-year escalation.
Okay. Mr. Church, do you have any thoughts or want to express any concerns?
No, I can see that if there can be some headway made here, that it's worth 60 days to deliberate between the parties, but the bond would have to be up front.
Thank you.
I could agree to that.
Mr. Brown?
I had already concluded that if they were willing to post the bond amount, which, by the way, we just approved new small minor bond fees, as I recall. And I would say if the engineering firm comes back with an estimate higher than the bond amount, that the bond would have to be increased to that as well. It needs to go both ways here, and I think the mining operators need to understand that it's part of the mining business to be fiscally responsible and be able to cover the cost of reclamation. And there are several of us here that are miners, we're miners. We understand you can do the reclamation cheaper yourself, but the burden of proof that you can do that is yours. It's not the division's. And in the interim, the division and this board is responsible to make sure that those costs can be covered. So, Mr. Chairman, I could agree to what you're suggesting here with an extension, but at a minimum, they need to post the bond that was estimated or calculated based on the most recent calculations.
Okay.
I think that's a really good point, Mike. It needs to go both ways, that they could end up facing a higher bond as well.
Okay. Well, Mr. Young, you've heard our hypothetical.
Let me say that I think you're being reasonable, and I would like the opportunity to talk to my clients. I'll represent that it's the Triumph Mining is basically owned in thirds by a 90-year-old woman, an 85-year-old man, and me. And I certainly could help with a bond. I don't know the financial abilities of my business partners. And so I'd have to talk to them about that. We haven't had the money. That's why we didn't put up the bond. And it was our hope that we would sell this thing to the Forest Service and negotiate some reclamation. But since that's clearly water under the bridge, we have to deal with the problems as they exist today.
You feel like
Mr.
you
Allen,
would...
could I ask you a couple more questions?
Absolutely.
These are placer claims, correct?
I believe they are.
Are they patented?
They've been patented since the 1950s.
Thank you.
Now, on the bond, are you thinking you would post, well, never mind. I shouldn't, that's not my position to ask that kind of question.
The bond has been posted by Rock Creek Gypsum, not by us. We would, and Rock Creek Gypsum at this point has not asked for their money back. As a matter of fact, they're thinking that they'll have to increase it when they file our NOI. But I guess what we could do is agree, depending on my conversations with my partners, post the additional amount in some sort of irrevocable situation so that the two amounts equal the 92,000. I say 92,000 because we're basically into the 3 years. So we ought to buy the 5. So I wouldn't want to waive my client's rights in this matter, or rights to appeal. It's obvious to me your tendencies in this matter, but there are bodies and courts above you that could look at it differently. We're very bothered by the fact that the notice of intent was filed before our deadlines were even up, and it seems like the bank's suing you on a note that's not even due. But having said that, I'm getting the tenor of what you're telling me here, and we need to try to find a way to make the whole thing work. We, as one of you mentioned, we want to try to protect the interests of the people of the state of Utah.
Well, let me ask you this. You feel like you cannot make this decision at this time on this proposal that we've put forth. So, and we're not inclined to delay this another month or two. So am I wrong in that you are not in the position, you feel like you're not in the position to commit the other two owners to this proposal?
I absolutely have no authority to commit the other owners to this proposal. And I'd like an opportunity to talk to them. And I frankly don't know, and what we would do about it, I don't know. Jean Danzy is very elderly, and I don't know her mental condition as of today. It may be good. Maybe Mr. Brandon Steele could tell us.
Well, I guess before we go there, division, Mr. Lyons or Ms. Haley, would the division feel like they'd be in a position to delay this until Mr. Young has had an opportunity to present this proposal to his partners?
I mean, I see Haley has her hand raised. I don't know if she wants to speak to anything before we say that. So maybe, Haley, I would just let you say what you were going to say beforehand. Sorry, Mr. Chairman, but I want to give her a chance to speak her mind, I guess, at this point.
Okay.
I just wanted to ask a question that kind of was going to, I think, what you guys were getting at, and that is that, you know, we did reauthorize a smaller, bonding for small acre mines, you know, a couple months ago. And so if Wayne, I wonder if Wayne has calculated what it would be, since we are up against the 3-year escalation period. If it's substantially higher than the 90,000, then you know, that would be something that potentially we should consider. And I also wonder if because the board is only meeting monthly, if it might be possible for us to continue on with the next matter while Mr. Young checks in with his business partners, and then we can, you know, maybe perhaps recircle after the final document. And that's all I have. Thank you.
Okay. Well, I guess, Mr. Young, is that something that you think you could accomplish in the next couple, maybe an hour and a half?
Oh, I apologize. I could not understand Haley's voice pitch. It's my hearing, I think. But is that what she said? Take a break for an hour and see if I can talk to my partners?
Well, she suggested we go on with the next matter and then circle back to this one that allows you enough time to talk to your partners.
That might be helpful.
Well, why don't we do that in the interest of trying to reach a solution to this that we can all agree upon? We can suspend this particular matter for however long it takes to hear the next one, and then take this back up a little bit later this afternoon. If there aren't any objections, then that's what we will do. Board members, any objections to that?
No, I need a 15-minute break.
Okay. What we'll do then, we'll go off the record for about 15 minutes because there's some other matters that need to be attended to. And we'll come back and move on to our docketed item number 4, which is the Wesco operating matter. And let's come back at 2:45.
Sir,
Yes.
I know you didn't have an estimate of time on me, and I if you would have asked me, I couldn't have guessed it. But do you have a sense of what we're talking about? A half hour or an hour and a half? Any sense of that?
I would say about 90 minutes.
Okay.
Yeah, at the longest end. If you can get it done beforehand and be ready to go in, say, an hour or hour and 15, that would be great.
All right.
Thank you.
Thank you.
I can hear.
Rich Borden, are you there? I can't tell you how much I enjoy doing this. Mm-hmm.
That proves how old we are. We don't miss Julia.
The rest of the kids in this room have no idea. Mike, can you give me a thumbs up if you can hear me?
I can hear you, Mr. Chairman.
Okay. Sorry to give you a false start. We need to figure out a little bit more about this upcoming matter, which I erroneously referred to before we went on break as Wesco. I was going the wrong direction. This is an Excel matter, but we're going to give a few more minutes here before we go on the record. Michelle,
Oh,
can you?
oh, okay. That's what I was going to ask.
Yeah. Sorry for the confusion. Give us about another 5 minutes, and then if that's not long enough, we'll come back and say give us 5 more. The record will go off for at least 5 minutes, and we'll be back. addressed our issues for this XCL matter and are prepared to move forward as soon as I can verify that all the board members participating electronically are present. I see Mr. Brown is up and ready. I don't have images of Mr. Borden or Mr. Church, but if you're there, if you could speak up.
I am here. This is Rich.
There you are.
I'm here.
Great. Oh, Steve. Okay. We're all set. Michelle, are you ready? All right. Got the thumbs up from Michelle. Probably the most important person outside of the board, right? Or maybe she is the most important. Yeah, you're more important than the board members.
We can live with that one.
So we will go back on the record and we will move on to the fourth agenda item, docket number 20221. Let me start over. Docket number 2021-011, cause number 130-06 in the matter of the request for agency action of XCL Energy Resources, LLC. Why don't we go ahead and start, Mr. Mayo?
Yeah, Chairman Hansen, thank you. Members of the board, Mitch Mayo on behalf of XCL Resources LLC, who is here today on behalf of the subsidiary company XCL Asset Co. LLC.
Thank you. Division?
Hi, this is Charles Lyons for the division.
Great. Well, Mr. Mayo, why don't you go ahead with your presentation?
Yeah, but before I do that, Chairman Hansen, something has come to our attention today, and without getting into too much detail, there is a concern or some issues related to potential BIA interests in the lands, and what I have discussed with Division Counsel Charles Lyons and with Board Counsel is I would like to propose a stipulated motion to do what this board has done in several past hearings, and that is hear the evidence today, make the decision today, but essentially defer the final entry of the order for a 30-day period so that the BIA has sufficient time, XCL and BIA and the board division have sufficient time to make sure that the BIA concerns are addressed.
And you feel confident that 30 days is enough time?
I believe so. If not, obviously, I'll be working in coordination with division and board counsel, and we should know that well in advance of the June hearing date. For what it's worth, I noticed that the June hearing date has been canceled. I don't believe that a board hearing would need to be reconvened to put this into effect. Board counsel can opine on that, but that's my position: is that this could be just a ratification at that 30-day mark.
So you're making a motion to stipulate, or you would like a motion rather from the board to stipulate that we can hear this matter, and if we approve that it would be held in abeyance for 30 days until the matter with the BIA is taken care of.
That's correct. It's essentially approved, but final approval will remain pending this resolution.
Okay. I believe that it's within my purview, without having to go through any other formal processes, that as the chair, we will stipulate to that and approve that.
Okay, thank you. Without that inconvenience aside, I appreciate that. I'd like to move on to this matter, which should be a fairly quick and easy matter for the board today. As I mentioned, I'm here on behalf of XCL Resources and XCL Asset Co. Collectively, I'll just call XCL. I have three witnesses today, the same three witnesses that the board saw last month: Mr. Kevin Hansen, Mr. Josh Sigler, and Mr. Mark Gravy. Could we please have Michelle swear in the witnesses at this time?
Can you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I do.
I do.
Thank you for that. Members of the board, Chairman, the resumes of these three witnesses have been submitted collectively in the appendix to petitioner's exhibit. If the board would like those to be submitted as formal exhibits, we're happy to do that. Those have been admitted as exhibits in prior causes. Mr. Sigler and Mr. Gravy have each been recognized as experts in their respective fields in prior causes before this board, including last month in a cause brought by XCL. With presumed stipulation of counsel and consistent with past practice, I would move to admit Mr. Gravy and Mr. Sigler as experts in their respective fields. Mr. Gravy is an expert in reservoir engineering and planning, and Mr. Sigler is an expert in geoscience.
Division, any concern with that?
No, the division doesn't have any objections to that.
Okay. Board members, any objections? Hearing none, I think we can accept them as experts in their for this matter in those fields.
Thank you, Chairman. Also, just to confirm, as has been confirmed today, with board's permission, I'll be moving for admission of all the exhibits at the end of our case in chief.
Yep. Sorry. Yes, that's fine.
Perfect. Last month, XCL showed up before you and had a request that involves some departure from past board precedents and a little outside the box thinking. The request before you today is much more simple, straightforward, and is supported scientifically. We are here today to seek modification simply of the lateral setbacks imposed upon the wells on the subject lands from 660 feet to 560 feet. One note, the subject lands comprise about 38 sections of land in 2 south, 2 west, and 2 south, 3 west. The changes requested by XCL today necessitate the modification of only one spacing order, and that is the order entered in cause number 139-153. I'll call this the existing spacing order. The existing spacing order established relevant to this hearing 1,280 acre drilling and spacing units upon the subject lands for the production of long lateral horizontal wells with 330-foot setbacks from the end of the well, what I often refer to as the heel toe drilling unit boundary setbacks, and 660 feet from the sides of the well bore, what we'll refer to as lateral setbacks. The requested modification, if granted, will reduce the lateral setbacks on the subject lands, as I said, 100 feet. And in doing so, will bring the setbacks into conformity with the setbacks in place on the adjacent lands in all directions, and will accomplish three very important goals. It will improve XCL's ability to plan and execute the orderly, consistent development of the subject lands. It will negate any competitive advantage that may accrue to offset operators by virtue of their 560-foot lateral setbacks. And it will reduce waste and minimize resource recovery, especially as it relates to the entry of the order last month, granting the 2560 spacing units. The board has jurisdiction over this cause pursuant to Utah Code Annotated 40-6-5 and 40-6-6. Notice was provided as required under Utah law to all parties legally entitled to notice under Utah law and to all relevant governmental agencies. Each of these mailings was sent either to the address provided or the last known address of record in the New Cheyenne County Recorder's Office and or in XCL's internal decks. Several of these mailings were returned undeliverable, where the return mailings contained notice regarding a new address. New mailing was sent. In addition, notice was published in the Salt Lake Tribune on May 2nd, the Uinta Basin Standard on May 5th, and the Deseret News on May 7th. I understand that notice was published also in the Vernal Express, but I have yet to see proof of that publication in the docket. No one filed a protest or objection to the request in this cause, and no comment letters have filed. In short, all interested parties have received timely notice of the request, and no one has commented, with the exception of the stipulated continuance for 30 days to clean up all questions. XCL would submit that everyone has received timely notice and no comment has been filed. With that and nothing further, I will begin with my examination of Mr. Hansen.
I'm sorry to interrupt, but could you maybe you mentioned this and I was sure you're going through some paperwork here, but why didn't we do this last month? Why didn't we consider this particular issue last month?
Well, there's a couple of reasons. One, these are, as the division staff and board staff can attest, really intensive endeavors to do these hearings, the mailings, the administrative work, the compiling of lists, the reviewing of things. And I think the short answer is a question of timing. Ideally, we'd like to fit every spacing change we could into one hearing. It would exhaust the board, in my opinion, unnecessarily complicate issues. And in this one, to be perfectly honest, we weren't ready to bring both at the same time.
Okay, thank you.
Yeah. Mr. Ananson, will you raise your hand? Thank you. And would you begin by stating your name and business address for the record?
Sure. Yep. Kevin Ananson, Anonsen, 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Okay. And your current position with XCL?
Vice President of Business Development and Land.
Okay. Have you testified before the board in land matters in Utah?
I have on several occasions.
Okay. Do you exercise a supervisory role over the lands associated with the request here today?
That's correct.
Okay. Can you please also provide the corporate and bonding status for XCL?
Yeah, sure. XCL is a Delaware corporate company. We're in good standing. Our principal place of business is here in Houston, Texas, and we are appropriately bonded with all state, federal, and tribal entities.
Okay. And we discussed this last hearing, but if you wouldn't mind discussing a little more in detail, the relationship between the two petitioners in this case, XCL Resources LLC and XCL Asset Co. LLC, and maybe just to the extent you're comfortable, who do you think of as the petitioner here, if you had to pick one?
Sure. I mean, Asset Co. Is the entity that holds the assets, a wholly subsidiary company of XCL.
Okay. So XCL Resources is the employees.
That's correct.
And XCL Asset Co. is the holding company, wholly owned subsidiary that holds the leases and operating rights.
That's correct.
Okay. Thank you. Just a reminder, Mr. Ananson is a fact witness here today, and we do not need to qualify him as an expert. With this, I'm going to try presenting Mr. Ananson. Let me try and get this presentation up, and I will have you confirm for me. Can you see this?
Yes, we see the, looks like we see your screen and it's not the presentation now. There it is.
Okay, let me see if I can get this full screen. Okay. Exhibit 1, Exhibit A. Let me begin. Exhibits A, B, and C. Do you recognize these exhibits?
I do.
And were these exhibits prepared by you or under your direction or supervision?
Yes, that's correct.
Okay. Exhibit A. Can you briefly explain to the board what it is they're looking at?
Sure. Red outline there on the map is this is a regional aerial map of the assets. There are 2 south, 3 west, 2 south, 2 west. As you notice there, just west of the red outline is the city of Roosevelt. And then as you'll notice, southwest of our red box, our area of interest, if you want to call it that, would be Duchesne, city of Duchesne. And you can see they're divided with the green line would be the county line for Duchesne County and Uintah County. And the assets we're discussing today are all located there in Duchesne County.
Okay, perfect. One point of clarification, I believe you misspoke. Roosevelt's to the east of the unit.
I'm sorry, yes, to the east, I'm sorry.
That's okay. Exhibit B, can you briefly describe this to the board?
Sure, kind of staying consistent with our red outline. The red outline is the subject lands that we're discussing today. And then you've kind of got the one there to the east and 2 South, 2 West, 13 and 24, kind of the loner out there. But all these lands are the, like I said, under the RAA. And then all the other colors there that you see, which is green, blue, we'll call that a red, and a purple, are previous requests, approved requests that actually have 560 setbacks. And so the yellow currently have 660. And so those are the ones we're requesting for the 560s.
Okay, and this isn't the full picture. I mean, the board shouldn't infer from this that anything in white does not have 560 spacing. Is that correct?
That's correct. We just pulled the XCL, some of the XCL units in the area and just kind of zoomed in a bit. There's actually a unit in there, which is 2 South, 2 West, 25 and 36, which is actually operated, or is it 25? Yeah, 26, 35. Yeah. It's actually operated by Oventive, and that's actually spaced as a 560. So anyways, just to be consistent.
Okay, so it's safe to assume that some of this white, if not all of it, is spaced at 560 lateral setbacks as well. This is just a subset you chose to display.
That's correct.
Okay. So if the RAA is granted today, the board would simply expand the lateral setbacks in these, what you called yellow identified sections, to 560, consistent with the blue, green, pink, and purple.
That's correct.
Okay. Does the request before the board today seek to modify anything else?
No.
Okay. Exhibit C. This one, there's probably not a whole lot of need to belabor, but tell the board what this depicts.
Sure, I'll go through it as quickly as I can. As we discussed in the last slide, the yellow there was the cause number 139153, which was all of the 660 lateral units, or the lateral section lines that we are requesting today for the request lands. And so the way, looking at it, the current lateral setbacks, like you said, there are 660, and then the proposed lateral setbacks on the depiction there on the right is requesting for the 560. So this is just a quick visual of what we're requesting.
Okay, and they're not drawn to scale, so there may not be an appreciable difference in where the red line is located. The point is, they're set at 660. We're moving them to 560.
That's correct.
Okay. Now, I'd like to talk about notice, kind of generally, if we can. In particular, I'd like you to describe for the board, XCL's process for notifying interested parties of an RAA. What do you do? How do you go about doing that?
Sure. So, the first thing that we do, and what we feel is the most important, is we look at our internal decks covering the lands, and that's the first place we go. And those decks were, what we got from our predecessor, Axia. And then also, those are also updated by XCL over the past, year and a half, 2 years that we've actually owned the asset. And so, we look here on our actual decks, because we feel like that's, like I said earlier, it's the most important spot, because we're constantly updating. We pay, millions of dollars, quite frankly, just to, keep these lists refined, update them, different things of that nature. The way we get those decks set up in our system is we get title opinions from a title attorney, and the addresses that come on the title in the title opinion are addresses of the last known address as in the county records. And if those, when we are setting up new wells or updating, if those addresses are different than what's in the title opinion, the reason why they would be different would be because we had an owner, mineral owner, landowner, working interest owner, whatever, notify XCL of that change, and so that's where we would update that. And so we feel like that's by far the best place for us to look and for us to pull these addresses.
Okay. So that makes sense. Step one, look at your internal decks. What's step two?
Yeah, sure. So step two would be, when we send out, these addresses or they come up as unknown, the first thing we do is we look on the county records, make sure we haven't missed anything, make sure something hasn't been filed from the date of the title opinion. We're fortunate enough that majority of our title opinions are pretty recent, probably average around 2017-ish. So feels like our decks our addresses and decks are pretty updated. And so that's the first place, or that would be the second place we'd look if they were unknown, unlocatable, or something to that extent. And so, once again, when we mail those out, if they come back as unreturned, we go do that additional research to see if we can find something. We look in LexisNexis, look in the county records, look in white pages, kind of all the different Google searches that, you can think of, and hope that we find the best place. We do not update those in our records, though, just because we don't know if that address is actually valid, if it could be a completely different person, and we have different audit controls that we actually have to go through in order to change addresses. We can't just do that on our own.
Okay. So, IRS audit controls, investor audit controls, but basically want to make sure you're not messing up the asset.
Of course, and to prevent fraud and things like that. So.
Sure. Okay. Because, addresses that appear, nothing can be on the internet unless it's true, right?
That's right.
Okay. Well, that's good. So the standard process, it sounds like, is look internally for the records that have been culled from the county recorder's office and updated by XCL staff and mineral owners in the basin, and fill in any gaps from the county records. Is that a fair summation?
Yes, of course. I mean, relationships and land are obviously very important. So we certainly want to make sure we always have those as updated as we can be. And, checks sometimes still go to these addresses. So if they're not updated, then we have unhappy landowners and mineral owners, and that's the last thing we want. So.
Okay. So XCL uses these addresses and names for more than just noticing requests for agency action.
Absolutely.
Okay. Did you follow this, what we'll call your standard approach in this hearing?
I did, yes.
Okay. And how successful, generally speaking, was your notice with respect to this request?
We sent out, I believe it was a little bit over 100. I believe the number is like 125-ish. Out of those, 10 of those were undelivered or returned undeliverable. Of those 10, 8 of those are probably ones that the board or folks at the board have probably seen before, ones that we've had force pulled because they're unlocatable, or ones that AXI has put in front of the board before. So they're frequent names that I'm sure folks have on the board and ourselves have seen before. So I believe 2 of them were actually deceased and still haven't been able to find the heirs.
So out of the 10 that were returned, 8 have been force pulled as unlocatable before, and 2 are deceased, and you haven't located the heirs.
That's correct.
Okay. And did you receive any response directly, or were any comment letters filed in the board docket in response to your mail notice?
No.
Okay. With that, I'm going to conclude. In consideration of these exhibits you prepared and discussed, A, B, and C, do you think the request presented is fair, reasonable, and meets the board's 3 statutory objectives?
Yes.
Okay. With that, I'm done with my examination of Mr. Hansen. If the division would like to examine each witness serially, or if they'd like to do it at the end collectively, preference?
Division, what would you like? Would you like to ask your questions now or at the end of the presentation?
I think it'd be best to just ask questions of each witness as they go. Speaking for myself on behalf of the division as counsel, I don't have any questions for this witness, but if it's allowed by the board, we do have Dane Doucette and Dustin Doucette, who I don't know if, based on the testimony that was just given, if any new questions that they may have arisen. So I would ask to maybe give them an opportunity to ask questions if they need to.
I think that would be fine if they have questions.
Dane or Dustin, do you have any questions to ask Mr. Hansen?
Yeah, no questions.
Okay.
All right.
Mr. Sigler, can you raise your hand for Michelle so she can see who you are?
It's me.
Thank you. And will you start off by please stating your name, spelling your last name, and your business address for the record?
Absolutely. My name is Josh Sigler, Sigler, and our business address here at XCL Resources is 600 North Shepherd Drive, Suite 390, here in Houston, Texas, 77007.
Okay. And your current position with XCL?
I am the VP of Geology here at XCL Resources, responsible for everything from asset evaluation to geologic operations as we drill these wells.
Okay. And based on earlier stipulation, I'd just like to remind the board and division, Mr. Sigler will be offering expert testimony here in the field of petroleum geology. I'm going to show you Exhibits D that you're looking at now, Exhibit E, and Exhibit F. Do you recognize these exhibits?
Yes, sir. Those exhibits were prepared by myself and my team here at XCL Resources.
Perfect. Thank you for that. Exhibit D, tell the board what this type log is and what it means, why it's relevant.
Absolutely. That is a type log from the South Altamont 102222 well, API well number 43013-51053, which is located in the northwest quarter of the southeast quarter of Section 22 of Township 2 South, Range 2 West in Duchesne County, Utah. The log itself is
Josh, I'm going to interrupt you. I'm just going to have you confirm where it is. So you said Section 22, 2 South, 2 West.
That's correct. Right there and northwest quarter of the southeast quarter. So basically just on the 2 of 22.
Northwest, southeast. There you go. Okay. Perfect.
Thank you, Mitch. And so this log was a log we use as a generalization for what we call the Altamont Bluebell North Mighton Bench project area. In this log, we are showing in the left or top track the gamma ray log, which records the lithology of the formation or is a proxy for lithology. And in the bottom track is a resistivity log, which is generally used to log the fluid types or fluid presence in formations. We also are showing the in the top bar above, just listing of the major substantive formations here in the Uinta Basin, from the Uinta Formation to the Upper Green River, down into the Lower Green River and Wasatch. Those formation boundaries being delineated by some major tops, including the top of the Green River, TGR3, and the Wasatch obviously being the top of Wasatch. And we've also annotated on there the Mahogany Bench marker, which is a prominent marker within the Uinta Basin.
Okay, thank you. And how many potential targets is XCL targeting at this point in this formation, to the extent you're comfortable?
Yeah, that certainly there's a number. I think may not be comfortable answering how many different ones we're looking at, but I think we broadly say we have 4 major benches that we are actively drilling in today between the Lower Green River and Wasatch formations.
Okay. Moving on to Exhibit E. Cross section A to A prime. Again, walk the board through this if you would.
Yeah, this is just a cross section, generally showing the lithologic character of the project area, starting at A on the left-hand side of the cross section, which is north and west of the area, and extending down to the south and east at A prime. Generally, the formations here within the Uinta Basin are quite continuous, which is exactly the kind of setup we're looking for when we're drilling horizontal formations. We've annotated on a number of the key formations, but probably most significant in horizontal development is the Uteland Butte Bench, which has been the primary target of horizontal development within our position and throughout the Uinta Basin.
Okay, and just for clarification, this inset on the right,
yes, sir.
The red outline and the cross section is significantly larger than the subject lands here today, which comprise essentially this area, about the left half of it. Can you explain why that's the case?
Yeah, and that's a great point, Mitch. I mean, generally, the reason we put this cross-section together and showed such an extensive area is to show how continuous the geology is throughout the subject lands and throughout our project area. And as such, we view the geology and effectively the drainage and the properties that allow us to frack horizontal wells and drain or produce oil from the earth, draining generally a uniform area with broadly speaking with each well.
Okay, sounds good. Exhibit F.
Yes, sir. So this is just a generalized view of what we view as fracture half-length. Unfortunately, one thing that with the last year, as we've become operators here in the Uinta Basin, we have it's been a time where economically we haven't spent quite as much on sciences as certainly the geologist in the room here would like to spend. Maybe a proper amount for the reservoir engineer, economics kind of people, but. We have had to lean a little bit more on what we see from the literature. And in this case, we've looked at a number of dockets presented by our offset operators to see what they're seeing as fracture half-lengths. And so we've found three newer documents that we find to be very, very good. Those are listed in the text to the left, but in general, the average half-length, the average maximum half-length, so we're taking the maximum half-length reported in each of the three dockets and saying what is the average of that, they're reporting about 330 feet of fracture half-length. Now, when you compare that to a 560-foot setback, that means that we then have about 224 feet where we are of buffer between the 1280 unit boundary and the tip of our fracture half-length, which is correlative to some of what our predecessors, Axia, they had done a similar study and found a number around 310 feet of fracture half-length from previous studies. So all these numbers are coming together fairly well, which gives good credence to the idea that 560-foot lateral setbacks are sufficient to protect the rights of the offset unit mineral owners, correlative right holders.
Okay, and you mentioned that you kind of collected this data from publicly available data that's been reported on and approved by the board in hearings in the past. In addition, isn't it true that you've used data that XCL's predecessor in interest, Axia Energy, has actually presented to the board, data that is now XCL data? So it isn't just a collection of other operators' data. This also incorporates XCL's own internal data. It's just not new data since XCL's acquired.
Absolutely. I think we think of the work that Axia did as foundational to what we do with our almost any project we're looking at in the Uinta Basin geologically. Those guys did great work. And we're just hoping to build upon that. And so some of the really excellent work they put together provides a basis for helping us understand what we're looking at when we're even looking to look at what other offset operators are presenting. We are effectively fact checking that against our work and Axia's work, and we find that that these newer dockets that we have collected, that all I believe come from at least the last 2 years, if not the last year, all are in alignment with what we saw from a number of Axia dockets that they've also presented to the board as they were establishing these units. In particular, cause number 139166 is one that we lean on heavily from Axia's time as operator of these lands to understand the picture they have put together of the lands.
Okay, thank you for that. That's helpful. One question, the board is really used to hearing when they talk about setbacks up against drilling unit boundary lines, two pieces of information: the frac geometry, the frac half-length, as which we've talked about, and the frac azimuth, or kind of the way I think that the angle that it's going. We haven't talked about the frac azimuth, but your depiction has it essentially a 90 degree to the wellbore. Is that what you anticipate it to be, or why did you choose that frac
Yeah,
orientation.
absolutely. And I think, one thing that's hard is as we're looking at these subjects lands, they are lands that actually cross some are stand-ups, some are laydowns, which are related to the change in stress orientation. But we actually chose to present the fracture orientation or frac geometry that we have put in Exhibit E here, correct? F, sorry.
That's F, that's right.
Yep, Exhibit F, as directly perpendicular to the wellbore, because it's actually, for only considering the lateral setback, it's the worst case scenario. If that fracture orientation were to be inclined in any orientation, it actually won't be, it would be less, or the distance that half length would drain away from the wellbore would be less at any other angle, such that this is really the worst case scenario to be considering in this application.
Okay, and so that azimuth is not representative of any sort of, we believe it's a 90-degree azimuth. It's just, we don't need to worry about which direction it's going, because even at the worst possible direction, there's plenty of buffer.
Exactly. Basically, we have said we did not want to confuse the issue in this hearing with what the different fracture orientations are, because we believe that in all situations, particularly this, as we've presented here, this generality would be the worst case scenario. And in any case, a 560-foot setback should be protective of the offset mineral owners.
Okay. And in your, it would confuse the issue, because coming up with a frac azimuth in this particular location would be very difficult, because each unit may have its own frac orientation as it kind of moves around.
That's exactly right, Mitch. Honestly, I'd phrase it slightly differently. It's more that we wanted to be respectful of the board's time and not have to go through the discussion of this unit will have an orientation that is perpendicular. This unit will be at 30 degrees. This unit will be at 20 degrees. It's just, it's non-material to the conversation today in the way we're presenting it in our view.
Perfect. I think I'm done with that. Mr. Sigler, in conclusion, I'm going to ask you just the same question I asked Mr. Hansen. In consideration of your exhibits D, E, and F, and based on your experience as a geologic expert, is the request today here sound and reasonable, and does it protect correlative rights, maximize resource recovery, and prevent waste?
Absolutely, and I think the biggest thing I would add is that if I were a mineral owner in any of these units that had a 660-foot setback while my neighbor had a 560-foot setback, I would look at that and want to know, is there a fundamental difference between my unit and the unit next door on a geologic sense that I should have, that the operator of my unit should have 100 feet less to produce my minerals? And I would say the answer is no. As such, that it is the most fair thing to align the setbacks in all of these units.
Okay. Thank you for that. I appreciate it. No further questions. Mr. Lyons, if you or the Doucette's have any questions for Mr. Sigler?
Again, I do not have any questions specific for Mr. Sigler. However, if Dane Doucette or Dustin Doucette has a question based on his testimony just given, please go ahead and ask.
No questions.
Okay. Board members, do you have board members? Do you have questions for Mr. Sigler? Hearing and seeing none, Mr. Mayo, go on to your next. Next witness.
And I will. Before I move on to Mr. Grady, I'd like to clarify one thing from my opening. I mentioned that notice was published in the Salt Lake Tribune, Deseret News, and Uinta Basin Standard. I mentioned that I hadn't seen notice had been published, or the proof of that notice being published, in the Vernal Express. As the wonderful board secretary, Julianne, has now reminded me, I'm an idiot. Vernal Express does not publish in Duchesne County. This request is all in Duchesne County land. So I just wanted to clarify, proper notice has been published by the board in all relevant locations.
Thank you for that clarification, and we will forgive that moment of insanity.
Thank you much. I appreciate it. And thank you, Ms. Carter, for keeping me on my toes. Mr. Gravy, would you please raise your hand for the court reporter and identify yourself, name, spell your last name, and business address for the record, please?
Sure. Mark Gravy, Graeve. Our address is 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Okay, and your job responsibilities and your title as they relate to these lands?
Vice President of Reservoir and Planning.
Okay. Based on earlier stipulation, again, a reminder for the board and division, Mr. Gravy will be testifying as an expert. Mr. Gravy, you've seen your exhibits G and H. You recognize these, and were these prepared by you?
Yes, sir.
Okay. Exhibit G. We saw similar slides to this last month, and so the board probably understands what they're looking at. Could you please walk them through the two differences and what, practically we'll see as a difference if this request is granted?
Sure. On the left hand of the slide, we have the current setbacks and development allowed within the DSU. So as you drill wells in different formations, you stagger them, moving from one formation to the next. And when you stagger them across the unit with 660-foot setbacks, you have 14 wells in that DSU. By increasing the setbacks or decreasing the setbacks, to 560 feet, you have room to alternate one additional formation on each side of the unit, which would take it to 16 wells per DSU. And beneath, we have some sample economics. If you're able to produce 14 wells in a DSU at 900 MBO and $60 of oil, that would generate $2.8 million of taxes and $7.4 million of revenue per well, 39.2 on the aggregate, and 103.6 million at an 18% NRI royalty revenue. On the right-hand side, same economics by increasing it 16 wells per DSU. The aggregate increases from 39 in taxes to 44.8, and from 103.6 in royalty revenue to 118.4.
Okay, and oil prices are at least at this point in time around or near exceeding the estimates here included. And when you say total revenue, you're talking about the dollars that will go to the mineral owners, the royalty owners.
Correct.
Okay.
Revenue to a royalty owner with an 18% NRI.
That's right. Thank you. So in essence, for each drilling unit, if this is approved, there'd be approximately 5 million in additional taxes fully drilled, and 15 million in additional revenues, assuming that 18% NRI.
Correct.
Okay. And this exhibit, Exhibit H, shows the same thing again, but from a different angle. Is there anything from this slide that you'd like to add or like to call out for the board in particular?
No, sir.
Okay. The one thing that I would like to point out is this 1,000 feet here, the white line kind of right underneath development. Can you talk about that and why, even though there's these wells are squeezed in, why that 1,000 feet is important?
Sure. Yeah, that's an illustration. So approximately 1,000 feet development well to well in the formations. It's important just because two wells that are drilled too closely together become uneconomic, and although oil prices have improved, there isn't a big margin for error. So both within a formation and within adjacent formations, you need to give yourself some relief in development.
Okay. That's great. Thank you. With that, Mr. Gravy, in your expert opinion, exhibits G and H, is the request presented here today the best, fairest approach to meet the board's 3 statutory objectives?
Yes, sir.
Okay. With that, I'm done with Mr. Gravy. If Mr. Lyons or the Doucetts have any questions?
Again, I don't have questions for Mr. Gravy, but Dane or Dustin, do you have any questions based on that testimony?
No, sir, no questions.
Okay, thanks. That's all from the division.
Okay.
Board
With that,
members?
Oh,
Hold
sorry.
on. Board members, you have questions of this witness? Hearing and seeing none. Please continue, Mr. Mayo.
Sure, I apologize for that. With that, I'm done presenting XEL's case in chief. At this time, it's probably appropriate to move for admission of our exhibits A through H. Again, the witnesses' resumes were attached as an appendix. We're not included as exhibits in this cause, but I'm happy to do so if the board would prefer that.
Oh, I think we're good.
So I guess to sum up, I'd like to move for admission of exhibits A through H.
I think that's acceptable.
Okay.
They're accepted.
I'd like to reserve my closing then at this point until the division has presented its case.
That's fine. Division?
Thank you. I mean, the division doesn't have very much to say. Otherwise, there's no opposition to this request and generally supports it because it does contribute to uniformity, consistency, and orderly development of the subject lands, especially in light of last month's hearing and order coming through. There's no opposition to this from the division, and that's it.
All right. Thank you, Mr. Lyons. Back to you, Mr. Mayo, for your summation.
Thank you. I'll keep it brief. You know, this is a fairly straightforward matter. XEL has met all the statutory and regulatory burdens to have this approved. And with the stipulation, the caveat that was included at the beginning, that there will be an additional 30 days given to address any BIA concerns, if any, to this request. I would simply suggest that the board has the authority and the evidence before it to grant this request, and I would ask them to do so. Again, with that caveat already explained.
All right, thank you.
I move to accept this request and approve it.
Is there a second?
Mike Brown, I'll second.
Discussion on the motion? Hearing none, we'll move on to ask Ms. Carter to call the roll call vote.
Mr. Richard K. Borden, how do you vote?
Yes.
Mr. Michael R. Brown, how do you vote?
Yes.
Mr. Stephen B. Church, how do you vote?
Yes.
Ms. Susan S. Davis, how do you vote?
Yes.
Ms. LaVon J. Garrison, how do you vote?
Yes.
I'm sorry, we didn't hear that.
Yes.
Thank you. Mr. Christy Hansen, Chairman, how do you vote?
Yes.
Thank you. Mr. Chairman, I have 6 affirmative votes.
Thank you, Ms. Carter. The motion is carried. And Mr. Mayo, will you go ahead and prepare the order?
I will, and I will also, obviously coordinate with division and board counsel and communicate to the board through counsel when the order is finally ready for signature.
That would be great after the matter with the BIA is completed.
Perfect.
Oh, I guess I have one more question for Mr. Sigler. Has he tendered his resignation and gone on to teach at the university?
I have not yet, sir. Still a lot of good work here to be done in the Uinta Basin. When I get that all finished, I'm very happy to continue on in that second career.
Great.
He did ask for Mitch to reference him as professor instead of Mr. Sigler. So
it's an honorary title, I believe.
All right, thank you. Well, I wonder if everybody's ready to go. I see that Mr. Young is back online. Division, you have your folks back on this matter with Triumph. I assume everybody you need is present.
I think everybody is present. I was looking through the participant list, and previously Luke Decker with the Forest Service was on, and I didn't know if that may be important if the board wanted to ask any questions of anybody from the Forest Service. I had reached out to him previously, and I think he might be coming back on at 4 p.m. I don't know, but if the board doesn't have specific questions for him, then the division should be ready to go at this point.
Well, I think we would like to get Mr. Decker's opinion or position on this matter, but I think let's go ahead and hear what Mr. Young has learned from his partners. And then when that's done, if need be, we'll have Mr. Decker give the Forest Service position.
Okay, and I can always, if it's helpful, I can reach out to him, via cell phone or something and ask him to hop on. So.
Yes, if you would, that would be great.
Yeah.
Thank you all. Thank you all for the break. I have had an opportunity to talk to Mr. Bob Steele. Bob and I have not been able to talk to Mrs. Danzy. On the other hand, on behalf of Mr. Chairman, you proposed something I think you called a hypothetical. And let me return with a hypothetical if I can. The notice of the letter of March 5th, 2021 indicated that Triumph had until April 30th to do reclamation. I would stipulate that there's a misunderstanding of what that meant. We thought that meant the road. Mr. Western has testified it meant all of the surface reclamation on the project. But having said that, we would be agreeable to stipulate that we would pay up to $92,000. In other words, for the 5-year extension within 10 days. If the division would be agreeable that we have until the date stated in the March 5th, 2021 letter, in other words, until October the 31st of 2021, either to have on file a notice of intent to operate with the suggested bond, reclamation, engineering, and everything required by the division, or the regrading and seeding, which we don't want to do, but would be done or be at least in place by October 31st, 2021. We do not want to do that. We believe this is going to be mined, and we believe it would be negative spending to reclaim and then have a mining company come in and just tear it all out again to mine. But having said that, and understanding the division's frustration with Triumph and our delays in mining on a regular basis, we would be agreeable to that.
So hypothetically, what you're proposing is that within 10 days, you would post the additional bond to get it up to 92,000, and that you would have until October 31 to either have a NOI submitted or you would go into reclamation. Is that correct?
Yes.
Reclamation has to be done.
Reclamation is completed by 10/31.
Well, I think we'd all understand that reclamation might be completed in terms of grading and seeding, but the seeding wouldn't be, probably good for a year or more. But yes, long and short, the way Alan Young looks at it is we've got until about August to get that new plan of operations, the notice of intent on file and being considered by the division, or we need to start reclaiming property.
Okay. Division, what are your thoughts on this?
Couple of things. So you mentioned a notice of intent being submitted. That notice of intent would need to be approved, not just submitted. Also, as far as the bonding amount, previously the discussion was putting that in line with what the current bonding rules would be. This is based off of that old escalation, and the division has kind of forwarded me what the updated bond amount would be, and that amount is $95,400. So I think the division would be amenable to agree to the continuance to the date proposed. Reclamation would need to be complete, either a new NOI approved. If those things did not happen, by whichever date the board thinks is appropriate, Mr. Young has put October 30th or 31st as that date. If there's non-compliance with that, it would need to be an automatic bond forfeiture at that point.
Charles, could you please clarify that that's for the 5-year renewal, the 95.4?
In this email, it says 3-year for 2021. This is, again, just kind of happening on the fly and getting emails while we're in other hearings and that sort of thing. So I can ask the division to put that 5-year amount forward if that is preferable.
Well,
I don't know what that is right now.
I think Mr. Young needs both amounts because he's weighing the current 5-year versus the updated 5-year and 3-year. If I'm him.
Okay.
Yes, in addition to that, I've learned recently and been told today that I have the right to question that and to file my own engineering plan, and it may be significantly less. And so any agreement to that effect would be subject also to my posting the 92 and then being able to come in and request a reduction based on an engineering study that would show the reclamation wouldn't cost that much, because we don't believe it would cost anywhere near 90,000. But that's me talking.
Mr. Allen, the board understands that, but you need to recognize if we have to do the reclamation, we don't have the advantage you have. We use handbooks and things to determine what it would cost based on contractor costs. So you certainly have that right to work with the division on the amount, but recognize the difference between the division doing the reclamation and you doing the reclamation. That's something you need to understand.
We're fearful of that, so we understand it.
I guess so. The question is, if we're going to put forth, we're saying that there's a 10-day requirement to post the bond. Do we also have 10-day requirement that amount being suggested by another third-party engineer and is within that 10-day period? It's not going to extend that 10-day period. We want to have the bonding in place within 10 days.
Yeah.
Whatever the agreed amount actually is based off of a third-party estimation.
Yeah, Mr. Lyons, I'm sorry you lost me. And then there was one other question I had. Maybe we're not even close to an agreement. You used the word approved mining plan. I understand that the plan needs to be legitimate and have reclamation and engineering and video of the slopes and things like that. But the word approved just makes this a non-starter, because I don't know that I can get Mr. Western and others to approve anything. And so it would have to be something that would be filed that meets regular basis. But the word approved is, I can't waste my money, another 30,000 of my money, and hiring engineers and everything else to have the state tell me it's not approved.
Ms. Souza, you had a comment?
Yes, thank you, Chairman Hansen. I'd just like to point out that the rules, I would highly suggest that Mr. Young go through the small mine rules. They do specifically lay out timelines that the division has to review NOI applications. And so the reason we are insisting on an approved NOI is because an NOI can't be approved until bond is posted. So if we have a new operator come in, you know, they're able to sell it, they have a new person come in, then that operator needs to have bonding posted before we can approve that NOI. It also, the rules also don't grant the division wide discretion to deny applications. If Mr. Young submits an application that is compliant with the requirements, within a very short period of time, the division must approve it. So it's imperative that the NOI be approved for this deal to work, because otherwise we can end up in a situation where we are now, which is we don't have adequate money. And thank you, I'm done.
Could you tell me what those time periods are, Ms. Souza?
I can tell you, or you can find them in the rules. They are in R647-3.
Thank you.
So I guess where we are is that there's a discussion about a difference in bond between the 92,000 and, I didn't write it down. What was that number again, Mr. Lyon, for a 3-year?
95.4, Mr. Chair.
95.4.
That's correct.
Yeah, and the 92 was for 5 years.
Well, I think before we broke, there was a discussion about that number that was arrived at in 2018 was based on a set of rules that have since been updated just a few months ago that increased the per acre cost in small mining reclamation. That under the new rules from a few months ago, that a 3-year bond would cost 95.4. So an additional 3,400 and only a 3-year instead of a 5-year.
Would that 3-year be from now or back in 18, so it expires about October?
No, I believe, and correct me if I'm wrong, Division, it'd be from now, right?
Well, that would be
correct.
I'm sorry, I didn't hear what you said.
That would be more fair. I think that I haven't spoken to my clients, but that's an additional $5,000 or so, and I think that would be reasonable.
Okay, so
if we have an agreement on the remainder.
And the discussion there was the difference between approved and unapproved NOI. And based on what Ms. Sousa was saying is that if you presented, in my mind, what I heard was if you presented a concise and well thought out NOI, that the division, and if it checked all the boxes in the regulation, then the division would be approving that NOI in a very short period of time. Is that correct, Ms. Sousa? I'm getting a nod, yes.
Yes, that's correct. I can say it out loud just so that it's on the record.
Okay. Well, then I guess, is there further discussion on the sticking point of the NOI, Mr. Young?
I haven't read the regulation that I was so kindly given. I apologize that I don't spend my life in mining regulations. I maybe should. Um, um, okay, that's probably reasonable.
Okay. Now, board members, what are your thoughts on what the? Okay. We're been requested that we go into deliberations. So we will go off the record. The board members who are participating electronically, if you could go to the other connection, we'll have our discussion and then come back and reconvene. So we're off the record for a few minutes. Okay. Let me check to make sure that we've got all our board members. Yep. I see the three gentlemen are on. Michelle, give me the thumbs up. Thumbs up. All right. We'll go back on the record. And I believe at this time, Ms. Davis has a proposal to read.
I'd like to make a motion that we grant the following, that Mr. Young and party will agree to a $95,400 three-year escalation bond clause or a $99,200 five-year bond escalation clause. This bond must be posted by 10 days from today. In addition to that, an NOI must be approved by the August board meeting. If there is,
Can you tell me what day the August board meeting?
the August board meeting should be August 25th.
Thank you.
So an NOI must be in place and approved at the August board meeting. If there is no NOI, reclamation must be complete. And by reclamation, we mean not just the street, but the mine site and the seeding. The reclamation must be complete by October 31st, 2021.
Having heard that proposal, Mr. Young, are you in agreement with that?
We are, Your Honor.
Thank you. Division? Mr. Lyons or Ms. Souza?
Yeah, the division agrees with that.
Okay. Thank you. Hold on just a moment.
I would like to add to this motion that if there's a breach of any one of those terms, there's an automatic forfeiture of the bond with no appeal.
Now, do we need to redo the motion, or can somebody second that knowing that what Susan just read was fine? So I'm looking for a second.
I'll second the motion.
Discussion on the motion, board members? Hearing none. Ms. Carter, could you do the roll call vote?
May I stop all of you 1 minute? I think that I agreed to the terms, but I don't remember the words "no appeal." It will be forfeited, but I can't waive my client's rights to appeal this thing.
He's not doing it.
Okay, just automatic forfeiture of the bond.
Yes.
Okay. The motion will say automatic forfeiture of the bond.
Okay. Pardon me? Oh, should we?
I'll second the amendment.
You're seconding the amended motion?
Yes.
Okay. Discussion on the amended motion? Haley.
Can I please clarify who the appeal would go to? Would that be appeal to the board of oil, gas, and mining? Or would that be a judicial appeal?
Ms. Souza, you have been reading me from the statutes. I would follow the statutes, if anything. I hope this resolves it. I hope we're mining gypsum and making big tax dollars for the state by August. But if all else fails, and if an appeal were filed, it would be pursuant to the rules of this hearing. It's my understanding that you have a right to appeal to the courts after other appeals are exhausted. What I sense is going to happen if we don't mine, we're going to work with you to get it reclaimed to save some of that money. And and have our own engineers and contractors contour those slopes and fill them in, because we can do it less expensively than a contractor. And so I think we'll be talking back and forth to one another about that.
So,
My primary concern is if this is a final board order, that appeal would then be reviewed judicially, which is, I'm not opposed to that, but it does make sense in my mind that it would be reviewed by the board if that were mutually agreeable to all of the parties. Because it's not specific in the board's rules, except that final board orders are judicially reviewable.
This is Mike Bagley, counsel for the board. Haley, to your point, I think that we haven't reached the merits, so the appropriate next venue of appeal would be the board.
You're right. Thank you, Mike.
okay. Are we all in agreement on this one? So I don't think we changed the motion at all. Ms. Carter, could you go ahead and ask for the vote?
Mr. Richard K. Borden, how do you vote?
Yes.
Mr. Michael R. Brown, how do you vote?
Yes.
Mr. Stephen B. Church, how do you vote?
Yes.
Ms. Susan S. Davis, how do you vote?
Yes.
Ms. Levon J. Garrison, how do you vote?
Yes.
Mr. Chris D. Hansen, Chairman, how do you vote?
Yes.
Thank you. Mr. Chairman, I have 6 affirmative votes.
Thank you, Ms. Carter. Mr. Lyons, will you prepare the order?
I would be happy to.
Thank you.
He agreed to send it to me for my approval.
Right. So I'll be drafting a proposed agreement and order, and it will be going by Mr. Young before putting forth to the board.
And it will, and I can say it will be our intent to have the money in either cash or trust by 10 days from today.
That's part of the agreement, yes. All right. Well, thank you all for the work on moving this forward. One thing before we adjourn this hearing that we need to do, I understand that it may be necessary to go into a closed meeting to discuss strategy pertaining to pending or reasonably imminent litigation on some other matters than what we've heard today, and shouldn't take very long, 5 to 10 minutes. I apologize to those who have to hang on. Board members, would anybody like to make a motion to go into a closed meeting?
So moved.
Is there a second?
Mike Brown will second.
Discussion? None? Ms. Carter, would you do the roll call vote?
Mr. Richard K. Borden, how do you vote?
Yes.
Mr. Michael R. Brown, how do you vote?
Yes.
Mr. Stephen B. Church, how do you vote?
Yes.
Ms. Susan S. Davis, how do you vote?
Yes.
Ms. Levon J. Garrison, how do you vote?
Yes.
Mr. Chris D. Hansen, Chairman, how do you vote?
Yes.
Thank you. Mr. Chairman, I have 6 affirmative votes.
Thank you. With that, we'll be moving into a closed meeting to discuss our issues not related to anything we had today. But we will be using our virtual boardroom, and at the conclusion of that closed meeting, the board will reconvene to adjourn. So, board members, let's go into our virtual boardroom, and we'll be back as quick as we can. We'll go off the record now.
Are we excused?
Yes, sir. Thank you for your attendance.
Thank you.
funny. I looked up Sage Advice and it's a bodice ripper. Seriously, it's this guy, bare chested.
Okay, we're on. Looks like the 3 board members are here.
And it's 99 cents.
We'll go back on the record to take a vote to adjourn. Is there a motion to adjourn?
So moved.
Second?
Second.
All right. Motion's been proposed and seconded, and we are adjourned. Thank you, folks, for hanging on until the very end.
Thank you, Mr. Chairman.
We'll see you.